she is the applicant, then that might make a difference. But if she's not an applicant, or is not an applicant, then she's not the party, which means that consent is not necessary. So the anterior question is, who's in fact the applicant?
It is the Office of the Public Prosecutor, my lord. I think this was judgment carried by the this court in the Part A judgment indicated that it is the Office of the Public Protector that is dividing the court and not within dividing in a personal capacity. So, in line with the fact that within dividing was suspended, the Constitution that provides that the new incumbent has the powers and benefits to act on behalf of the public prosecutor's office, and that incumbent has instructed the current attorney to withdraw from the matter. So applicant providing does not have instruction to authorize any attorney or counsel on her behalf when she cited in an official capacity. So she doesn't occupy the opposition.
So if I understand you correctly then, that the Office of the Public Protector has formally withdrawn the application and there is no objection from any of the parties who presently before. Is that it?
But then doesn't that go against what she deposed in the very founding affidavit? Because she says, I'm the applicant in this application in my aforementioned capacity as a public protector.
My lord, not only does she look at the judgment to deal with whether she was in fact here in her personal capacity.
That's what she says on the papers. That's what we must deal with, isn't it? Of course, there are areas where you've got to make a distinction between the incumbent and the Office of the Public Protector and the title Public Protector. But it seems to me that she brought these proceedings in her capacity as a public protector, which she was, and I think she still is, albeit suspended. So these are the proceedings that she brought. She says so in the papers. Her suspension might have an impact on her ability to execute the functions as a public protector. But would that put an end to a litigation which she has instituted? It does not seem to follow.
If she's not occupying that office, then this one was that that's not supposed to continue the proceedings. And as indicated, this court has noted that in respect of her capacity. It is noted that it is not recognized that what is in front of the court is the office of the public protector and not included on in the personal capacity. There's no ambiguity in the judgment that is included as you can see in front of the court. So to the extent that she's suspended, she no longer exercises those powers. And so the incumbent, as we mentioned earlier, has indicated that they do not wish to proceed and the withdrawal must be accepted.
Thank you.
It would seem that this withdrawal, if I understand correctly, was only done even before the consent of the parties could be obtained in conflict with the rules. Is that correct?
So, my lord, if I understand the rule, if one withdraws prior to the matter being set down, they do not remove the consent of the parties. If the withdrawal is effected after the matter has been set down, it is only then that one requires the consent of the parties. And as I said earlier, the public protector's office only learns after the matter has been set down.
Yes.
That after it is filed with the withdrawal notice that the matter has been set down.
Yes, but the matter was already enrolled.
But see, the public protector's office was not aware of that. So at the time when it filed the withdrawal, it wasn't aware and that it required consent from parties. So it wasn't necessary.
Was it not incumbent upon the Office of the Public Protector to find out even before the withdrawal notice whether the matter was enrolled or not? Before that application was, rather the notice of withdrawal was filed.
So, my lord, after the notice was filed, nobody raised an objection to public protector was not privy to the proceedings that happened. It received a copy of the judgment, as I understand, and I'm saying this informed it of clear instructions to that. It received a copy of the judgment, which informed it of the findings that were made in Part A. And I believe there was correspondence between Advocate Mkhwebane and the Office of the Public Protector in relation to the judgment. And it was, I believe, also communicated in correspondence as to whether or not that office would in fact proceed with the application. So whatever the decision was would have been communicated to Advocate Mkhwebane even before the withdrawal, and the public protector's position, I believe, has been made known to her after the judgment. I don't see that Advocate Mkhwebane or the legal representatives, and again, they don't quite indicate that they have in fact advised the public protector's office at the Matter Criminal, but one would imagine that if she was being competent at the time, and if she, as a legal representative, were conducting the proceedings on behalf of the public protector's office, at the time when they were informed that the public protector's office no longer wishes to proceed with it, one would imagine that they would have advised the public protector's office that the matter has already been set out. So if you wish to do something about it, this is what you need to do, but the matter has already been set out. And I don't believe that communication or the public protector has been informed by the legal representative or much that is by the office.
All right, thanks, Mr. Mpofu.
Thank you, my lords. My lords, I'm going to try and simplify this matter so that it doesn't take up much of our time. It's a very unfortunate issue to be raised in the manner that it has been raised. It will feature, I was just conferring with my learned friend, Mr. Breitenbach, that it will feature in his section, rather Rule 7 application as well. But let's just dispose of this part of it very quickly. Confusion is this, my lords. My learned friend says that she's acting for something called the Office of the Public Protector. Now, and she's coming here to withdraw from this matter. Now, to withdraw the application. Firstly, there is no party before the election. It's called Public Protector, the Office of the Public Protector. So such a party cannot withdraw when it's not part of the proceedings. That's the first thing. And I will also raise this in relation to the Rule 7, because again, the same type of confusion reigns there. My lords, all one has to do is to just look at the cover page. We have thousands and thousands of pages, but just look at the very cover page, which is the heading, and see if there's a party called the Office of the Public Protector. You will find none. The party that is there, even originally, even if you look at the Part A heading, is called the Public Protector of South Africa. There's only one person who's called the Public Protector of South Africa. It's Advocate Busisiwe Mkhwebane. And as the presiding judge has pointed out, she set out in her founding affidavit how she's bringing the application. Now, my learned friend's problem is that she has two problems. One, that the party that she represents has never been a party to these proceedings, and it is not a party to these proceedings even now. And that is borne out by what she said. When she says, I was not aware of this, I was not aware of this, that's exactly why, because all the parties were aware of whatever was happening, because obviously they would be served with all the papers. But they could not be served to other people who are not parties. So that's the first issue. You cannot withdraw from an action that you are not party to. The second one is that, let's assume that that entity was a party. Then it's what the court has raised. Rule 41 is very clear about withdrawals. You cannot withdraw without the consent of all the parties. It says so. And when we received the letter on Saturday that my learned friend is referring to, we wrote immediately back to say, for the avoidance of any doubt, we made the point that I've just made. PPSA, the party that he represents, is not a party here, but also that no consent is forthcoming from our side. So that should be the end of it. But just so that I can foreshadow the discussion that we will have with Mr. Breitenbach, because it will also assist here. The matter is very simple, my lord. The Public Protector Act makes this distinction clear. There are three parties, let's call them theoretically. One is called the Public Protector of South Africa, that's the applicant. In our respectful submission, that party is inseparable from Advocate Mkhwebane, because there's only one Public Protector in South Africa. It's like if you say the President of South Africa, you know who you're talking about. But then there is indeed a different entity, and it's a juristic entity called the Office of the Public Protector. That entity is not before you. It's not a party to these proceedings. And if it was, you would know, because in the part that the presiding judge was reading, it would have said, I act for that juristic entity, and here's their resolution or whatever, in the normal way that juristic parties are cited. And that, my lords, you'll find in section 5. Yes, section 5 of the Act. And we've tried to explain this in numerous letters, my lord. But section 5.1 of the Act says, the office of the Public Protector shall be a juristic person. Simple. So there's a difference between a human person and a juristic person. The juristic person called the Office of the Public Protector is colloquially known as PPSA. We've indicated that in the replying affidavit. The party that my learned friend is acting for. That juristic person described in section 5.1 of the Public Protector Act is not a party to these proceedings. And it cannot withdraw, it can't do anything, it can't talk, it's not here. Because it's just a simple confusion which we've really, with the greatest respect, explained ad nauseum in letters. And even in the affidavit, the replying affidavit, you will see that we explained it in the context of the section, or rather of the Rule 7 application. So that should really be the end of the withdrawal. I think my learned friend she doesn't have to withdraw anything because she's not here. If she wants to sit and watch the proceedings, that's fine.
Do you want, Mr. Breitenbach, you also want to?
Lord, I would like to get your permission just to deal with this at a housekeeping level. Because I strongly suspect that you don't have before you what you would need to deal with the context between my learned friends on my left and right hand side.
Absolutely, there's nothing. I don't have the notice of withdrawal. I don't have the emails that are being referred to. So we just,
The notice of withdrawal is in the papers, and I will take the court to that if necessary, but I don't want to detain you very long. The fact of the matter is that although none of us have seen any notice of step down, we were notified towards the end of last month that the matter had been allocated to yourself. And that was on the back of a letter from a learned friend's attorney written with the consent of the parties which we asked that the matter proceed today and tomorrow, subject to the special arrangements in relation to our submissions because of difficulties and I don't know. There is no application before this court in terms of Uniform Rule 41(1)A for leave to withdraw the present matter. But there's obviously a cloud hanging over this question. And what I would like to suggest that just the level of housekeeping is the following way forward so that we can get on with the arguments and that subject to obviously the issues that my learned friend today is going through. As my learned friend Mr. Mkhwebane pointed out, there is an application by my clients, the first and second respondents, in terms of Uniform Rule 7.1. It was delivered on the 23rd of January, supported by my client's answering affidavit, and it was for leave to challenge the authority of CNAGA Incorporated to represent the Public Protector of South Africa, the named applicant, following the suspension from office of the incumbent, Advocate Mkhwebane, on the 9th of June 2022. And that application extends, as you have seen from the affidavit of my client Mkhwebane, to CNAGA Incorporated's authority to deliver the notice in terms of Uniform Rule 20.1 on the 17th of June on behalf of the Public Protector of South Africa, and to seek the amended relief to the amended notice of motion which accompanies it. So that is before the court, and my client will be motivated in moving that application in the course of your book. But as the court would have seen from the affidavit, which includes much of the correspondence between the incumbent Advocate Mkhwebane between CNAGA Incorporated on the one hand, and the Deputy Public Protector who's been acting in his stead since the 9th of June, and indeed the CEO of that office on the other. All of these documents and papers on both sides will be taking into the issues in relation to Uniform Rule 7.1 application of crystallized into a single legal issue. There's no dispute about that. And the issue is really this: what is the effect of Advocate Mkhwebane's suspension on her capability to continue prosecuting the present application in her capacity as the Public Protector of South Africa? That's the question. As His Lordship Presiding pointed out, she says in her finding affidavit, paragraph 1, she is the Public Protector of South Africa, and she's the applicant in this matter, in her words, in my aforementioned capacity as the Public Protector. The legal issue is, what is the effect of the suspension on her capacity to continue prosecuting the present application? You've heard my learned friend. Her side, she contends that despite her suspension, she remains the Public Protector of South Africa. On the other hand, my clients contend, as it happens in line with the correspondence in the papers from the Deputy Public Protector of South Africa, following the 9th of June, our side contends that the prosecution of the present application is a function of the Office of the Public Protector, which due to her suspension is currently vested in the Deputy in terms of Section 2(a)(7) of the Public Protector Act. That's the legal question. How does that provision relate to Section 1943 of the Constitution? What are its implications for this case?
Without interrupting you, Mr. President, so if I understand you, your suggestion is that it's not necessary to resolve this issue of withdrawal, because one way of resolving it is by dealing with the Rule 7 question.
Correct. So there's no need to deal with this issue up front.
All right.
It's not going to go away. The court will not be blindsided later. My learned friend...
It's a matter that is squarely before the court.
Correct. She may or may not bring an application in terms of Uniform Rule 41(1)(a), but if my client's Uniform Rule 7 application succeeds, the same point will have been resolved. And there's another and final thing which means we should move on from this point at this stage, and it's this. Advocate Mkhwebane has put an application in terms of Uniform Rules 10 and 12 for leave to join/intervene. That application is not opposed by anyone. No one wants the outcome of this particular regard to be that all of this must start again. We're packing the courtroom. We've got volumes of leverage files which the court has read, and they're ready to hear the case. If my client is right and the Uniform Rule 7 application succeeds, in other words, leave is given to challenge CNAGA's authority, there will be nothing that Mr. CNAGA can say, because it's a legal question at the end of the day. But the point is that there will be an applicant before this court. I noticed with interest that when my learned friend put himself on record today, he did so on behalf of the first and the second applicant. I see in his latest affidavits filed in the 653 application that the affidavit is the first and second applicant. Now, that application hasn't been granted, but there is no need to for any debate about that, and that can indeed be granted up front. Your Lordship will then be seized of an application by at least Advocate Mkhwebane. The only question being whether the Public Protector of South Africa, this institution created by the Constitution, is before you too. And so with respect, my suggestion is that we pin this issue. There will be a debate. You'll hear it today between my learned friend Mr. Mkhwebane and I on that issue, and your Lordships can then deal with the matter, this issue in their judgment. Thank you.
So, Sprakenbach, if I understand the tail end of your submission, that there is a joint application and an intervention application, or alternative intervention, in the event that court were to find that the true applicant is in fact the organization Public Protector South Africa. One possibility then is that that application for intervention or joint will be granted first, and then there's nothing really to withdraw from the Public Protector South Africa's point of view. What that entity can do then is merely abide the decision of the court, because that entity wouldn't be withdrawing the application with the application still before the court. Then the court doesn't necessarily have to deal with that issue.
I would hesitate to agree with the last proposition you put in. It's up to any party, and the rules provide the basis for that, to seek the consent of other parties to withdraw. This is after a case has been set down, as seems to have happened in this case on about the 29th of June last year. We researched it and we received an email from the court after the Chief Justice notifying us of the composition of it. They can either seek the leave or they can apply to withdraw. If an application for withdrawal were to be made between now and the end of the case, then that application would have to be adjudicated, and there may or may not be a need for further submissions in that connection. But there isn't such an application before you right now. All you have is a notice of appeal, and what you do have is the issue raised by the notice of appeal squarely before you, which is going to be decided in relation to another interlocutory which is before you. The implication, and the reason for my hesitancy for dealing with the last proposition is that if my client is right, and that ever since the 9th of June, Mkhwebane has not had the authority to give instructions to doing in connection with this case. What you will have, obviously, a consequent invalidity of the notice of amendment, the amended review sorted in the notion of motion, the steps taken to have the matter set down, instructing counsel, etc., to appear on behalf of the Public Protector of South Africa. So the implication will be practically that the court can safely proceed on the basis that the Public Protector of South Africa is no longer a party to this case, because as I'll show in my argument, the correspondence couldn't be clearer. Those who control the Public Protector of South Africa do not want this case to carry on. But that doesn't matter in practical terms, because Advocate Mkhwebane will be here in a personal capacity. And no one, certainly my side, will not be seeking to prosecute the office of the Public Protector in these circumstances if this application doesn't succeed. And I have no doubt that the other respondents will not be doing so either. So the practical effect will be you will have an application for you. Advocate Mkhwebane will be the applicant in that application. She will be seeking relief. The relief that she does in this application in her personal capacity. And we know from the correspondence to which we'll get, the Office of the Public Protector will be funding this application to a certain extent, namely to the extent that it concerns the challenge to a suspension. All of that is in papers that will be taken to. My proposal is that we move on. If your Lordship is having heard my learned friends and talk to him now on the Rule 7 application, think it doesn't cover the field, I've submitted it would, then your Lordships can give whatever directions you consider necessary to deal with the gatekeeping issue. But in my respectful submission, I dispute that deal with the gatekeeping issue. But I've been detaining you very long on the gatekeeping issue.
Ms. Mkhwebane, you want to respond? It seems to be a sensible proposition to get on with the matter, because one of the issues raised in the matter relates to the question that the Office of the Public Protector perhaps wanted to clarify. It might be that it's concerned that if the matter goes against the applicants, it will be settled with costs, and if that's the issue, that is the issue that will be covered by the Rule 7.
Yes, Mother, I agree with the proposal on my side. Mr. Redebach, this basically is one of the issues that the parents incumbent of the that was to act that one public protector is suspended, that the deputy becomes
Performs the function. All right, thank you. And then that should then take care of that matter. The other matter is now the Rule 65E.
That's correct.
Justice, we brought an application under Rule 65 on Saturday, that's the 23rd of July. I'm not sure if the court will all of the justices have copies of that application.
We have, and in order to facilitate us moving on, it seems to be unopposed, but the question might be the counter application. So perhaps you can just address us on the counter application part, on the basis that the application to admit that affidavit is granted.
That is so, Justice. If I could perhaps deal with it in this way. The first point is that the President's position is not that he is refusing to make that response available. Where the applicant says so at paragraph 342 of the answering affidavit, that is not correct. The court would be fully aware that the President's position is that he had every intention of making it available. He received the email that advised that it shouldn't be made public because of concerns that it could place the integrity of the investigation in jeopardy. And in light of that, he's drawn this information to the attention of the court, and he will abide whatever direction that the court gets in relation. As Justice Nichols pointed out to me, that the applicant, now Lucy refers to her as the applicant for the purposes of my argument, she's brought a counter application, and can I have the court just look at the affidavit that is supported by? And the first point is in paragraph 3. She says, due to the urgency and to avoid an unnecessary concern, she does not oppose the admission of the affidavit. And then she says that the President has failed to make full disclosure. It's unclear as to why that is so. But she then goes on to say that she wants reasons as to why extensions were sought. This has been dealt with in the President's replying affidavit, even though the point is made that it's entirely irrelevant to this application. Secondly, she says it raises the issue of being made available under circumstances of confidentiality. Justices, I might only this point having said that the President abides with. And that is all the parties appear to be on the same page that they ought to have no postponement of patient rights. If that is the position, it's hard to conceive of what the purpose of this would be for the purposes of this litigation. With the issue in the hand. And then the last point is the basis on which Applicant Mkhwebane suggests that the response should be made available. In response to that counter application, the President for the admission of the further affidavit.
Thank you, Mr. Pillay. Mr. Mpofu? Does the applicant really want to insist with the counter application, or does she want to get on with the main matter? Because it seems to me that seeing that the matter is proceeding, it won't serve any purpose.
My Lord, yeah, because we've already wasted so much time, I'm inclined, if I can just take instructions, because again, this is another non-issue.
It's far removed from the real issue.
It's a non-issue. Let me just say this, my Lord, maybe before I can take instructions. The importance of the counter application, maybe we actually follow the example of the first, how we dealt with the first issue at the housekeeping level. For us, the only issue, and that's why we talk about full disclosure, my Lord, is that the answers to the 31 questions is an issue that is relevant, as you know, my Lords, to the whole issue of the acting public protector having taken the place. You'll remember that the President says it doesn't make any difference to Acting Mkhwebane because, after all, the investigation is continuing. We have countered that effectively in the replying affidavit by saying that giving this as an example, saying, for example, the idea of giving him an extension, which in our respectful submission was undeserved, shows exactly the point that
Advocate Mkhwebane should make that comment cautiously, because somewhere she complains that she's not being given enough time to respond to certain issues in the committee. But that's
yes.
Just by the way.
No, that might be so, my Lord. In fact, Your Lordship is probably making the same point that I want to make, which is that whole issue as to whether the relevance of these questions. Remember, the President says 3 times, and I don't want to take you there now, that he has cooperated fully with the investigations, and we contest that statement. And therefore, the relevance of these answers, when they were given and so on, is relevant in that context. So I'm simply saying, my Lord, that this is not an issue that should detain the court at this stage. When we debate the issues around the timing of the suspension and so on, this issue will come back as to the answers, the timing thereof, and whether we need to see those answers in order to sustain that argument. And the court will make a ruling at that stage.
You wanted to take instructions?
Yes. Yes, my Lord. Yes, I have instructions on the basis that I've outlined.
That we can admit the affidavit, we don't have to dispose of the issue of the counter application.
At this stage.
Very well, then the application in terms of Rule 65E is granted, and the matter relating to the counter application stands over. The last issue on housekeeping matters is Mr. Masuku. Your papers have always been coming in late, but we've wasted enough time as is already, so I think we'll accept your lateness of your papers and get on it tonight. Thank you.
Thanks. And may I just mention as well that my letter can be sustained and will be able to contribute to points that we intend to submit after lunch.
Thank you. Mr. Mpofu, your 10 minutes starts.
Thank you, my Lord. Just, right. My Lords, I intend to use the 10 minutes to really give a roadmap, context. They say that famous saying that says, in law, context is everything. Our approach is going to be that this matter really is quite simple and circumscribed insofar as it relates to Section 172 of the Constitution. Because that's really what essentially this matter is about. Very simple, declarator of inconsistency with the Constitution in terms of 172(1)(a), and then setting aside that conduct in terms of section 172(1)(b. That's it. If you put aside for a minute the section 173 application for the common law and so on, development of common law. But as they say, sometimes some things look simple, but actually they are complex. So behind that simplicity is the following complexity, which does not need to detain your lordships except just for context. Now, the lordships would have seen that there are thousands and thousands of pages of paper in this matter, and that it has multiple legs. If it was a Shakespearean play, it would have acted this and seen this and so on. But to simplify it, to explain where this matter has been, this is the fourth time that it is sitting before this court, before a full court of this court. And there are two other applications in the Constitutional Court related to this matter, and there's one that is outstanding in the Constitutional Court. And as if that is not complicated enough, there is a process in Parliament in terms of Section 194. So it's an octopus with 8 different legs. But the good news is that your lordships really have to deal with what, in my estimation, with the greatest respect, is probably the simplest of all those 8 legs, to the extent that I've described, that it's confined to Section 172(1). But unfortunately, context being important, when all of us are addressing the court, we will be referring to some of these other 8 legs, but not for them to be resolved, but merely to paint a particular picture in whatever context. The lordships by now would know that there was an application, let's call it the Saldanha J Court. That was the February 2020 application. Full court, 3 judges. Thereafter, there was, in August of last year, let's call that one the Bartman J Court. That was part B of that application. Then, after that, there was an appeal, a consolidated appeal in the Constitutional Court by the Speaker and the DA. So let's call that Concord 1. After that, there was then a rescission application. Let's call that Concord 2. And the order in that matter was issued on the 6th of May. Then on the 18th and 19th of May this year, let's call that the Erasmus J Court, was then part A of this matter. And then there is a rescission application, let's call that Concord 3, that is pending before the Concord. And then, of course, now number 8, we are here in the Nuku J Court, if we follow that nomenclature. So that's the roadmap. Then, of course, the parliamentary process is a parliamentary process. It's unique, but its relevance will also become clear as we discuss. Now, in the context of all that, what then happened, and this will touch on some of the interlocutory issues which I will address after the 10 minutes, being the one just mentioned by Mr. Breitenbach of the Rule 7, the issue of urgency, I'm not sure if that is still an issue, but I'll touch on it for what it's worth. Again, I'm not going to have a separate address on urgency. In my respectful submission, the facts as we develop them will indicate the urgency of this matter. By the way, all these stages that I've referred to, except the rescission application, were urgent applications. Even the appeal was an urgent appeal. We opposed it, but it was granted by the Constitutional Court because of the nature of the matter. But all the other stages, including the most recent one, was brought on an urgent basis. Now, again, having said it's simple, I'll sound like I'm contradicting myself, because if you look at the issues, my lords, the issues are quite weighty, very, very weighty issues. Why do I say so? You just have to look at the parties before you. You have the head of a Chapter 9 institution, you have the head of state, you have the head of the legislature. It can't get more serious than that. And then you have the chairperson of the ad hoc committee, or rather the Section 194.1 committee, who's also a party. And then you have the political parties. All the political parties in South Africa are parties to this application, some participating parties, others non-participating. So that's the extent of the nature of what we're dealing with. Now, in our addresses here, we will touch on at least 8 of the 14 chapters of this Constitution. Our Constitution has 14 chapters, and this matter deals with about 8 of those. First chapter, the foundational values. Chapter 2, the Bill of Rights. Chapter 3 is about cooperative governance. Chapter 4 is about the legislature, parliament. Chapter 5 of the Constitution is about the executive and the president. Chapter 8 is about the judiciary and the administration of justice. And Chapter 9 is about Chapter 9 institutions. And then we'll also touch a little bit on Chapter 10, Section 195, which deals with the public administration. That's how, if it was a course in a university, that's half of the year in constitutional law. So there are ramifications, but just to allay your lordship's fears, we're not going to go into each of those chapters. I'm simply saying that there are intersections between them. Let me give you an example. The central piece of the central section of the Constitution that we'll be dealing with here, 194.3a, is already a unique type of section because it conflates within it the executive and the legislature. You'll remember that Section 194.3a says the President may suspend a person after the start of the proceedings in the of the committee in the National Assembly for the removal of that person. So there already you have a potential separation of powers issue because you have the head of the executive, but the trigger is in Parliament, so to speak. So that's just an example of where these intersections will be. And then, of course, in our respectful submission, and this is one of the issues where we say the Part A court, with the greatest respect, got it so wrong. It is the implications of Chapter 3 of the Constitution. Because that court, for some reason, found that that doesn't feature, partly because of the kind of debate we had here. Because according to that court, the only person, or rather the only entity in front of them was the Office of the Public Protector. They say that in paragraph 77 of that judgment, there's no such thing. There's no party before you, which is the the Office of the Public Protector. So, and as I said, if a court could find it wrong, literally, on these thousands of pages, just on page 1, all you need to do is to pick up the thing, and it says, in the matter between the Public Protector of South Africa. There's nowhere where it says in the matter between the Office of the Public Protector. There are matters like that, by the way. I know them, I've been in them, but this was not one of them. This is a matter of the Public Protector of South Africa, which is one person. So that court, with the greatest respect, and I'll deal with it later, got it so wrong to the effect that your lordships know that we say that stare decisis doesn't apply because it's a different type of case anyway. But even if stare decisis applied, the decision is clearly wrong anyway. So on either leg, with the greatest respect, the whole hullabaloo about the Part A court, we will demonstrate effectively, is really an issue that should not detain the court for long. So let's come back to the simple side of the matter. My lords, there is Section 172 is the heart of the remedial powers within the Constitution. Lawyers like using Latin words to complicate easy things. So we say ubi ius, ibi remedium. That's just fancy lawyers. All they really try to say is that where there's a right, there's a remedy. Ubi ius, ibi remedium. So we are all, and it's a natural thing, we all emphasize the rights. If you talk about the constitution of any country, there's a right to this, the right to this, the right to that, right to that, everyone knows the rights. But the remedy side, which is crucial, is normally forgotten. But it is the heart, it's the nucleus of the whole thing, because what would be those rights worth? They would just be a shopping list of wish list, as it were, if they were actually not enforceable and if they could not be remedied. And that is why this case becomes so simple, with the greatest respect. Because all we are saying is, the Section 172(1)(a) says that any conduct or law, and that is found in Chapter 8, just to go back to the signpost. Very simple. If I had the means, the technological means, I would, throughout the next 2 days, just put up somewhere Section 172, because as I say, that's what the case is all about. It says, when deciding a constitutional matter within its power, a court, including this one, we know that because it's defined, must, very important, must declare that any law or conduct that is inconsistent with the Constitution is invalid to the extent of its inconsistency. Let's forget the law for now, because this case is about conduct. So, for the purposes of this matter, when deciding a constitutional matter within its power, a court must declare that any conduct that is inconsistent with the Constitution is invalid to the extent of its inconsistency. This also takes care, let me pause there, because that will take care of another wasteful exercise which I don't want to get into. The word must in that sentence is crucial, because a court has no choice in the matter. Once conduct is inconsistent with the Constitution, the court must declare it invalid. Otherwise, this Constitution will just be a piece of paper which we must all throw away, and it will be meaningless. Now, the difference between that jurisprudentially, between that and, for example, interdictory relief, which is what we sought before the Erasmus J. Court, is like chalk and cheese. Because the court knows that when you bring an interdict, the court has a discretion to grant or refuse the interdict. Even if you meet the 4 requirements, the court can still say, well, you've met the requirements, but in this case, we're not going to grant you. It's tough for lawyers, but it's the law. Whereas here, we're dealing with a different animal altogether, where the court must declare. It has no choice. It is enjoined by the Constitution itself. And that's all we really want. We will take you for the next 2 days, whenever we have an opportunity, to specific sets of conduct. And we will get into detail sometimes when it's needed, but it will be only for one purpose and one purpose only. To explain that conduct that we are talking about is inconsistent with the Constitution, and mostly Chapter 3 of the Constitution or other sections, 181 and so on, about the independence of the public protector. We'll get into that. But every time I open my mouth for the next 2 days, it will be for the simple purpose of explaining that the conduct that I will be describing under any prayer, all the prayers, is inconsistent with the Constitution. And that's it. So it's either the court will agree with me that the conduct that I've just described, whether it's about the suspension, how the suspension was done, whether it's about the letter that was written by the Speaker, whether it's about anything, the court will either agree or disagree that you have described, Mr. Pope, is inconsistent with the Constitution or is consistent with the Constitution. Finish and clear. And once then that happens, once I've convinced or failed to convince the court about the inconsistency of whatever I will be talking about with the Constitution, then comes Section 172(1)(b), which says, when deciding a constitutional matter within its power, a court may make an order that is just and equitable, including and so on, the court knows. Now, that you will find in, in prayer 4. So what I've just spoken about now is in prayer 3, all the various conducts. We say, we ask this court, declaring in terms of Section 172(1)(a) of the Constitution, 1, that the conduct or decision of the Speaker in issuing the letter dated 10th March, it's on page 2, my lords, page 2 of volume 1.
Wasn't that amended?
Yes, I'm reading from the amended one. It's on page 2 of volume 1
of
Bundle B.
Bundle B.
That's correct, my lord. Yeah. So I've just read the first one. So that's what 172(1)(a). Next one, the conduct and or decision of the President in initiating or pursuing and or implementing a suspension process against the applicant. So we want to declare it around that. The decision to suspend the applicant issued on 9 June 2022, declare it in the report of that. The conduct or decision of the Section 194 Committee to commence and or proceed with the Section 194 removal process while the matter is sub judice. And then 3.5, all decisions taken by the committee between 22 February 22 and the date of this order to be null and void. And then the implementation of Rule 129(a)(d) of the National Assembly without its due process and amendment by the National Assembly. So if you look at the overriding words at the bottom, say all those things to be irrational, unconstitutional, and invalid. And by the way, that's just another small issue about Section 172(1)(a) that people forget. Once a court, as it must, declares conduct invalid, inconsistent with the Constitution, then that conduct is invalid to the extent of its inconsistency. Here's the interesting part, and this is going to be crucial in another context. Unlike a normal declarator, and I think it was O'Regan J. in the Metro Rail or Rail Commuter's case who said that the declarator in 172(1)(a) is not the same as the normal declarator that you get in in the Superior Courts Act. Why? Here's the most important thing, and it's actually difficult to even accept. Even for a lawyer, there's something that sounds not right about it, but it's right.
It's difficult to internalize.
And it is this, Honorable Justice Luke. When a court makes a declarator under 172(1)A of something that happened last week, actually, the declaration of invalidity doesn't start last week up to now. Once a court declares something invalid, that invalidity goes to the 8th of May 1996, on the day the Constitution was adopted. That's a crucial thing. It will become clear later why that is important.
That's very difficult to understand, Mr. Mkhwebane, because by the 8th of May 1996, that conduct would not have existed.
Once the court declares it today, that's exactly what the court is saying. It's saying, so let me make an example about that.
It nullifies it as if it had never come into existence.
It has never come. And that's why the Constitution in Section 172 has a counter for that. The counter for that is that in certain cases, if the other side asks for it, then they ask, as they did in the Constitutional Court 1 case, they ask that the order of invalidity must not have retrospective effect.
That's now on Section 172, 1B.
1B, yes, and just and equitable.
Yeah.
Yes. So most, if it's something that's obvious, let me make I don't want to make an example about somebody who is here, but there was a case about, let's say I was in charge of some inspectorate, and then it is found that my appointment 3 years ago was wrong, and the court declares it invalid in terms of 172(1)A. Then it would mean all the licenses, or whatever it is, that have been granting for 3 years must be nullified. But that would be ridiculous. And that's why the Constitution then provides for the other side to then say, no, in this particular case, there must not be the automatic retrospectivity. But absent that, every declaration of invalidity goes back to the adoption of the Constitution. Crucial. Now, so here we've made the life of the court quite easy, because all we have asked for in terms of Section 172(1)B is simply setting aside that conduct. Once, obviously, you won't get there. If you don't get the declarator, there's nothing to set aside. But once you get the declarator, we then ask in prayer 4 that setting aside the conduct end of decisions referred to in prayers 3.1 to 3.6 above. That formulation is also important, and it's going to be crucial when we talk about the letter of the 10th of May. Because the only defense that is given to that is that, no, that was not a decision.
Is that the 10th of May or 10th of March?
10th of March is called.
Yes.
10th of March letter from the Speaker, in our respectful submission, prompting or triggering for us to be here today. If that letter had not been written, we would all be doing different things.
The 10 minutes are up, so we can engage with you now.
At this stage, well,
but has that letter got any consequences? Because yes. What triggers the powers of the president is what the Constitution says, with or without the letter.
Yes, no, that is true, my lord. But it has huge consequences, and I'll explain like this. As I say, quite literally, if that letter had not been written, we would not be here. And I'm not exaggerating. I'll explain why that is so. That letter is the one that triggered the letter of the 17th. It's common cause. And that letter of the 17th is also common cause from the president himself, that the process of suspension started at that point. In other words, he implemented the Audi and so on, which culminated to the 9th of June suspension. So, and the president, it actually has immense implications if you look at the Sarfu case, because it also deals with the issue of abdication.
I think now we are moving on to the President. I just want for the time being to deal with the conduct of the Speaker, because as I understand it, 3.1 is concerned mainly with the Speaker,
Yes.
and that's the conduct
Yes.
of the Speaker.
No, my Lord, with the greatest
But of course there will be
overlaps.
They will overlap.
Of course, yes.
So
No,
I just want for me, because I'm still struggling to understand whether it really matters.
Yes, yes.
Because if the proceedings had started, they had started. If they had not started, they had not started.
Yes. No, my
As
Lord,
a matter of fact.
maybe let me just explain it like this.
And that seems to me to be the most crucial.
Issue.
Yeah.
Yes. Let me explain it like this, my Lord. And in fact, unfortunately, Your Lordship cut me when I was really explaining here the
But you can pack it and come back to it.
No,
if that's
I'll
what
deal
you
with it. But I just want to put it in the context in which I was raising. I was raising it to distinguish between a decision and conduct. That's all I was doing. I was saying, for example, that letter of the term, the defense that is put here is that it was not a decision. I'm saying that doesn't matter. We are not saying it was a decision, we're saying it is conduct. And conduct is all the court has to do, like, I'll be sounding like a broken record for the next 2 days. All the court has to do is the conduct of the Speaker in writing that letter, was it consistent with the Constitution or not? Yes or no? If it wasn't, then it must be declared unconstitutional. If it was inconsistent, or rather it must be declared unconstitutional, and if it wasn't, it must be irrespective of the question that Your Lordship is asking, which I will deal with now quickly and get it out of the way. What we say about that letter, my Lords?
Maybe just before you answer that, because maybe that's the gist of what I am grappling with.
As God.
If that letter stated the position factually, then we would have no qualm with it.
Absolutely.
All right.
Absolutely. No, absolutely. Your Lordship, in fact, you've taken the words out of my mouth. That's exactly the point. If that letter was stating the position that we agree with when we come to the interpretation point which Your Lordship has touched on, then it would simply be, that's exactly the issue we have, is that that letter was misstating the law, number one. Number two, it was not authorized by anything. You see, this thing we call the rule of law, my lords, says this, and it's again another well misunderstood thing. If you are a public functionary, you cannot act outside of the powers that are given to you either by the Constitution or the statute or rules or regulations or whatever. You can't just wake up and say, oh, today I'm just going to go and drive to GR and do this and the other. When you go and do that, someone will say, if you are doing it as yourself, you can do whatever you want as a human being. But when you're doing it as a public official, the question must be asked, who empowered you to do this? Which section of the Constitution or which legislation? And people always make a mistake. They say, no, you can do anything that is not prohibited. No, it doesn't work like that. If you're a human being, yes, you can do anything which is not prohibited. But if you are the pharmaceutical case, the federal case, and all those cases say that if you are a public functionary or body, you must do that which you have been empowered to do. All of us have to do that. Otherwise, there'll be chaos. So, I ask a rhetorical question in respect of that letter. Where did the Speaker derive power to do that, to write that letter? And the answer, I answer it quickly, nowhere. And that's relevant not for the purposes just of the rule of law, but for what I'm going to suggest were the motives of him writing that letter.
Is it not in keeping with the corporate governance?
Cooperative governance?
Yes, yes.
No, it's not. Section 41 of the Constitution, no. Let me explain. Section 41 of the Constitution, of course, says that there should be the committee between organs of state and so on. But if you look at the rules, I'll come to that, Rule 129. For example, Justice Lekuleni, it says that once the committee finishes its work, the inquiry committee, then the Speaker must write to the President to inform the President that the committee is now finished. There's another one earlier, I think, to do with the independent panel. Once the independent panel, the Speaker must write to the President. But no, there's nowhere where it says the Speaker must simply wake up and write to the President to prompt him so that he can trigger a suspension, which is really what happened here. But as I say, I'm not making a big issue out of that because it's going to be bigger when the full picture becomes clear of what really are we dealing with here. What are we dealing with here? Why would a speaker do this? And the pieces of the puzzle will become clear as I speak.
But generally, the answer to your question wouldn't be incumbent upon the Speaker to write to the President when, in her view, that when the power of the President can be exercised in terms of Section 1943 to suspend.
It might well be Justice Nugu, but then it should have been put in the rules. That's all I'm saying. If that is so, then it's very simple. Parliament knows that. It would have said, well, not only at only 2 stages must you write, but also even on this 3rd stage. But Parliament didn't do that. In fact, you'll see, I'll refer you to a letter which was written by the Presidency to Mr. Hoffman earlier, where he was asking for a suspension much earlier, I think in 2021. And the response was, no, we can't do that, Mr. Hoffman, because the process has not started, and when it starts, we will make inquiries and so on and so on. I'll demonstrate that it's not incumbent. And it actually goes against what I'm saying, which is that you don't just do something because you think it might be a good idea. You do that which you are empowered to do. Otherwise, you have a duty to explain it. That's why they call our Constitution the culture of justification. So every time you do something that might have an adverse effect on another human being, you must be able to justify it. That's the sum total of our Constitution, as Professor Etienne Murenik once described it. It introduces a culture of justification. Nobody can just exercise power just because they think it might be a great idea. So that's dealing with the issue of that letter. But what is the real significance of that letter? It is that it was clearly intended, as Justice Nuku has just indicated, to trigger the suspension. That's our only interest in it, because it was intended to trigger the suspension of my client. And it did, by the way, because we all know, I don't think anyone can seriously dispute the fact that then it led to the letter of the 17th, it then led us to all the other things that we know. But let me go to the heart of that matter, again, correctly prompted by Your Lordship, because the heart of that matter is this issue of interpretation of 194.3a. The reason I start with that issue, even before the issue of the conflict of interest, which has got more scope for debate, is for 2 reasons. Because if we are correct on the interpretation of 194.3a, then, quite frankly, the implications of that will be so cross-cutting that it will cut through the entire case.
There's a domino effect on everything.
Domino effect on the speaker, on everything else that we're asking for. Thank you, Justice Nuku. And that's the reason we thought it would be prudent to start with that issue. The issue of conflict of interest is, nice
debatable.
And debatable, but also, for lawyers, exciting. But the real issue is that
the hard law.
Absolutely. The hard law issue is the simple matter of the grinding interpretation of 194.3a. Because if that is so, then let me put it like this to simplify it for the non-lawyers. If the proceedings have not started, as we contend that they haven't, or if they had not started at the time of the suspension or at the time of the trigger, or in fact they have not even started now as we're here, as I'll demonstrate that they haven't. If we're correct in all those, then it means simply this, that nobody has the power to suspend. So it matters not whether it's President Ramaphosa or President Mbeki or whatever. No one would have, because the power will not have been triggered. Whereas with the conflict issue, it's a fallback position in a way, if you frame it like that mentally. Because it says, okay, let's then suppose that we're wrong with the interpretation issue and the proceedings have started and so on and so on. Then we say, even in that case, then President Ramaphosa should not be the suspending authority. And that's the conflict issue. So that's the relationship between those two issues. So let's start with what has correctly been described as the hard law issue.
But then in addressing that issue, we must be mindful, I think your opponents are saying that that issue has been decided. And so you must persuade us that that court that decided that issue was clearly wrong.
Yes.
Yeah.
Yes, that's what they say. Firstly, I say that we don't even have to go there. Let me explain the relationship between the two types of courts. And with respect, I hope I'm preaching to the converted in the presiding judge, because this, what I'm going to say, has already played out in this court. Namely that a negative finding in Part A, in this case I'm referring to the Saldanha J Court, has had no bearing on a positive finding in the Batman J Court. Why was that so? Because that court should have said, the Batman J Court should have said, Mr. Mpofu, what are you doing here? Didn't you hear that Saldanha J said all your points, including the one of legal representation, including the one of whether there's a judge who must sit in the independent panel? Are you okay, Mr. Mpofu? And then I would have walked out with my tail between my legs. But that court could not raise that because it's a manufactured defense. There's nowhere in the world where the main application, the judgment of the interim court, the interim order, binds the main application. As we say, it means people don't understand the expression pendete lite.
But is the argument not this, that one of the issues that the applicant had to establish in respect of Part A was that the powers to suspend have not been triggered because the proceedings of the Section 191 committee have not started.
Yes.
And so that court had to deal with that issue. And my reading of that judgment is that it deals with that issue, and it says somewhere, a line somewhere has to be drawn in the sand and all of that.
Yes. Well,
so it's squarely, it deals with the issue, not peripherally, but because it was one of the decisive factors which would then trigger that court's discretion on whether to grant the interdict or not.
Thank you. That is so, Justice. But please hear me out. I'm saying, and that's why I thought a shortcut would be to use the example of the Batman Court and the Saldanha J Court, because that's exactly what happened there. One or two of the central issues that was used as part of the right to be asserted in the Saldanha J Court were the issue of legal representation and separation of powers. All I'm saying, Justice Nubi, is that didn't stop that other court to say, well, but Mr. Mpofu, what are you doing here? Because that was a central issue and it was rejected. So you also cannot do the same because of what I was explaining, the difference between an interdict as a jurisprudential thing and a declarator. So these two cases literally have nothing to do with each other, because in the one case, the issue was being raised as at a prima facie level as a springboard for a prima facie right, admittedly. But here, now, we're in another world. We're in the world of Section 172(1)(a) of the Constitution, where we're saying, irrespective, this court, because the reason that relief was being asked for pendente lite. Pendente lite is another fancy Latin thing. Simply means pending the litigation. Which litigation? This one. So it would be foolhardy to say that application pending this litigation is now getting rid of this litigation, because this is actually the main application. It just doesn't make sense. So that's the first issue that the first assertion, with the greatest respect, is that it's a confusion between interdictory relief, interim interdictory relief at that, and the main case. Outer, for example, is a case well known by everyone, with features in as to whether the relief might be granted in Part A. But here, there's not going to be any discussion of outer, because that's irrelevant for the purposes of this court in the main application, the main application. That's just, as I say, it's a jurisprudential thing of mixing oil with water and saying the water means that the oil must be stopped. But let's say that I'm wrong about that. And let's say that that case had actually dealt finally with that issue. By the way, no, I think that falls into my second point. I will demonstrate with the greatest respect that in any event, even if, because my first point is that stare decisis has got nothing to do with this. But let's assume I'm wrong. Then, in applying stare decisis, we know that, and that comes to the point that you are raising, Justice Smith, that a court of similar status is not bound by a decision of that court if the first decision was clearly wrong. And I'm going to address that point specifically on the issue of the starting of the proceedings. Now, this is an exercise I tried with my learned friends last time to no success. Because I was saying to them, please, everybody, when you stand up, the first thing you must tell us is when did the proceedings start? I tell you, you'll have, at that stage it was, I think it was, the DA said it was the 16th of March, the date of the handing over of the independent panel. The Speaker said it was, in some way they just say July. I think they just give up in trying to fix a date. But they say, somewhere around about the 20th or 21st of July. That's what they say. The chairperson of the committee says it was on the 20th of July. Now, there's a new version now that's flying around that it was actually on the 22nd of April when the letter was written. And then there's another one which says it was the 11th of July when last week when the parliamentary inquiry started. That's how, and then of course, as if that's not enough, the Part A court then comes with another thing that says, it's almost like goes to the DA version. It says as soon as the independent panel finished its work, then, or when the report was referred, I think they used the word referred. When that report was referred, then it started. So you have as many, if I and I'm not exaggerating, if I took pieces of paper and gave all my learned friends and say it's a secret ballot, when did the thing start? I promise you the vote will be very close. Maybe there'll be 5 who say it started in March, another 3 will say it started in July, another 2 will do. But I'm challenging my learned friends now. Everybody who stands up must tell this court when in their version did the proceedings start and why. Why am I saying that? I know it's almost tea time. Let me round off this point.
Okay, I was going to remind you that
Yes.
we're going to take tea time so you can round off so
Yes,
that I
let
don't
me round
interrupt.
off this point. Let me round off this point. And it's because that's the real big point I'm making is not the secret ballot thing. The real big point I'm making is this. It is impossible, my lords, with the greatest respect, that a date so important in our constitutional makeup, a date on which a president can suspend a head of a Chapter 9 institution, that date is unknowable. This one says this one, other one says this one, other. No. That date should be fixed and it should be easy for everyone to define because it's a monumental date. It's not just some date, you can say roundabout, give or take. And and that alone, if the respondents, all of them, even if you were to use Plascon Evans, if all of them have different versions as to what the date is, that is a giveaway that A, the dates that they put are wrong, and B, that the dates that we put, they cannot remember.
But that's not a matter that falls to be decided on that basis because this is a question of interpretation.
Yes. After the interpretation exercise, there must be a date.
So it's just the facts that have played out, and then on the basis of that fact, you look at the provision, and then you determine what that provision means in that context.
Absolutely, Justice No. All I'm saying, I agree with you.
So it does not matter who says what, but all you must tell us, this is what has been happening, and from that we can then assess this is when the power to suspend is triggered.
No, I don't agree with that, Justice Nugu. Let me explain why.
Okay, you can explain that after
I'll explain
the
after tea.
tea
Thank you.
adjournment. What is adjournment?
No. Thanks. Thanks.
They're the only people that
that court has decided whose car it is. When the main case comes, it might well be that that court finds that actually the person, me, that it had denied the access to the car is the true owner. So the two things literally have nothing to do with each other. The one is just to capture a status quo pendente lite, without determining really the rights. The other one is, as I've shown, a serious matter of where a court must declare a particular conduct without any discretion. So that's the irrelevant point, Justice Francis. But I'm saying...
So just in other words, an example that comes to mind is if you are able to establish on a prima facie basis the right in respect of the interdict, that does not guarantee you that you are going to succeed in the main
absolutely.
And vice versa. If you have not established a prima facie right in terms of the Part A, that's not to say your case is doomed.
Absolutely. That's the irrelevance point. Thank you. I think the court has understood that point. But I'm saying then, assume I'm wrong with that point. And actually, the Part A court is capable of binding the Part B court. Then I'm saying, then we're talking about two courts of equal status. And that's where your second question counts, Justice Francis. That's because if on the first, the thing about clearly wrong doesn't even feature. It's just incongruence. But if I'm wrong about that, then I'm saying in any event, even if this judgment was capable of being binding, because it is clearly wrong, this court is not bound by it. Thank you. I'm sorry.
Again, sorry to interrupt.
No, of course.
You see, because if I understood the judgment of the Part A judgment correctly, they seem to concentrate more on the issue of issue estoppel and res judicata. Let's leave aside res judicata for the time being. But issue of estoppel, that is the same issues are being determined by a different court, and a subsequent court then is bound by that issue determination. So it's a bit different from stare decisis,
100%.
and maybe a bit different from res judicata. But the point is, a court has decided that same issue. Surely it must have some relevance to a subsequent court.
Yes. Now, thank you, Justice Francis, again. Now, let me clear that up. That debate doesn't feature in what we're discussing now. You are quite right that they said in relation to, I think it was the issue about sub judice, they said that that issue, there was issue estoppel because the Saldanha J court had decided that matter, and I think even the Bartman J court, and one might even say the Constitutional Court. That's a different debate. What they were saying there, and our counter to that, in fact, let me debate it now just to show how clearly wrong that judgment was. What we say about that is that, no, the issue, even if you narrow it to issue estoppel, forget about the res judicata. You can't say the issue is an interim interdict. You can't define an issue to that level, because then you can never, it means, again, let's take this example.
Sorry. Just in fairness to that court, they made a clear distinction between a cause of action and an issue.
Yes,
so,
but that's exactly what I'm doing. I'm saying let's forget about res judicata, which is about causes of action. Let's talk about issue estoppel. Let's confine it just to that. Just confining it to issue estoppel, the issue in the Saldanha J court was whether the rules were constitutional, right? The constitutional validity of the rules. It went on up to the Constitutional Court. The issue before the Erasmus J court was not, it was on the assumption that the rules were constitutional. And we were saying that the application of the rules in this, that's why we don't have the proceedings started and so on and so on. So it was a completely different issue. It doesn't work this way that if I go and ask for an interdict, and let's say it's refused, and then 2 months later, the person, the offender, does something else, I can't now go back to court because they say, no, you were here 2 months ago and you wanted an interdict. That's it. you're done. No. Because I'll be saying, I'm now bringing on new facts. This person has now beaten me up or whatever. No court can ever say, I'm not going to hear you because last year you were here on another complaint. That's just completely wrong, a wrong application of issue estoppel anyway. But the point, the reason why I was saying that was just on that point. The point we're debating now is a different one, which is whether, not on issue estoppel now, but on either, I don't quite know whether my learned friends invoke res judicata or stare decisis, but I'll assume they're invoking stare decisis. The issue is that stare decisis doesn't apply for the reasons that I've just explained. Alternatively, if it applies, I'm busy now going to demonstrate that that court was clearly wrong. Now, and I'll do that with the greatest respect if the court allows me. I'm going to do it in a piecemeal fashion. In other words, I'm going to do it now in the context of what we're debating, which is have the proceedings started. When we deal with the other issues, I'll also show how wrong that court was and so on. So I'm not going to do like a full-blown analysis of that judgment. Now, let's come back to the issue at hand, the hard law point. It's the same question that you may pose to that court. What I call the not multiple choice, the secret ballot case. That court, with the greatest respect, is even worse with my learned friends, because it has something like 4 versions as to when the proceedings may start or may not start, and so on. It says in paragraph 95 of the judgment, he, meaning the president, you'll find that at page 239, sorry, 239, that's volume 3 of NLP. I know this is duplicated, this judgment. I hope this is not one of the parts where we said Thomas and Reed.
239.
239, my lord. Yes.
Okay.
And maybe while your lordships are looking for that page, let me sneak.
We have it.
You got it, yes. Let me sneak in a quick point, which must just be at the back of your lordships' minds. That the judgment in Part A is on appeal, is being appealed against. Now that's another crucial issue, but we'll come to that. But it must be signposted, and it is being appealed particularly or specifically on this issue and other issues, but on this issue of when the proceedings started. At 95 to 239, it says, he, meaning the president, only has the power to suspend after the first respondent commences proceedings to remove the applicant. Let me pause there. This is a big issue. We have introduced a ground that says that the proceedings that are taking place now in Parliament are actually not removal proceedings. This is a very important point, because we are saying that those proceedings are not removal proceedings. If the chairperson of that committee has been at pains to tell anybody who cares to know that these proceedings are not removal proceedings, and he's right, because the proceedings there are defined very clearly in the rules. Their function, there's only one function only. It is to determine the veracity of the charges. Now, this is a crucial issue. If those proceedings are about determining the veracity of the issue, then how can you call them proceedings to remove? It's like saying, this example I was making to my team here. It's like saying, when you go to court and you are charged, and we call that imprisonment proceedings, before anybody finds you guilty of anything. I mean, or if you are being taken to a disciplinary hearing at work, they say it's dismissal proceedings. No. These are proceedings to determine the veracity of the charge. Once you are convicted, then you are into sentencing proceedings, or you can call it imprisonment proceedings. So that line is very crucial. And here's the problem that my learned friends are going to have. To be honest with the court, even myself, when we argued this matter in relation to Part A, the thrust of the argument was on the fact that the committee in Section 194.1 is the same as the committee envisaged in 194.3A. And I'll demonstrate now that that might not even be the case. And that is why, my lords, we went to, sorry, I'm sorry, my lords. Oh yeah, here we are. That is why, if your lordships go to page, I think it's 27, I think. Yeah, page 27 of bundle of volume 1.
Bundle B.
Bundle B, my lord, yes. Sorry. Yes. You'll see we plead this, my lord. Yes, page 27. We plead this, and by the way, nobody responded to this. We say, in respect of the ground of illegality relating to the interpretation section 194.3a, and more specifically, whether the removal proceedings envisaged in that section have indeed started. Very important. In other words, the removal proceedings envisaged in 194.3a, have they even started, irrespective of what is happening in Parliament now? And then we say there are no new material facts, and I intend to rely on the amendments in Bundle A. In other words, it's just a legal point. Then we say the suspension is clearly ultra-virus because the proceedings envisaged in Section 194.3a, when properly interpreted, have not yet started. Had not yet started on the 17th of March, and in any event, the current process does not yet constitute removal proceedings. Right? So we say the same thing that the chairperson of the committee has been saying. These are not removal proceedings. Now let's go to the section. And as I say, we made that point clearly in all those paragraphs, and nobody responded. We say, advise full legal argument in support of these admissions will be advanced at the hearing. That's where we are now. So, we say, it says, the president may suspend a person from office at any time after the start of the proceedings of a committee of the National Assembly for the removal of that person. That's what we call removal proceedings.
So the committee of the National Assembly must be what is colloquially referred to as Section 194 committee, or is that not so?
No, that's another mistake. I'll come to that. That's how we've been referring to it, and I'll demonstrate that that might be not quite correct. Let me start by just declaring, I have no doubt that the committee that is sitting in Parliament now is a Section 194.1 committee. That's common cause. The question I'm posing in paragraph 60, 61, and 62 of the supplementary founding affidavit is whether that committee that is sitting there is is the committee envisaged in 194.3a. In other words, a removal committee, for short.
But now if you read the Constitution, it seems to be that's the only committee that, because it's that committee that is going to make a recommendation to the National Assembly. There's no other committee.
A lot.
Otherwise, it would mean that we end up nowhere.
No, my lord. With the greatest respect, it's not like that. Let me explain this because this is crucial. We can't apply the logic like that. The question is, what were the framers of the Constitution? What did they have in mind in 1996, not last week, when they were crafting 194.3a? Remember, and this is caused, it's actually a natural, almost a natural reaction. When the people were crafting the Constitution, these rules were not in place. There's a 23-year gap between the two things. So we can't say, no, they thought that sometime in 2018 there'll be a committee, and therefore that committee will therefore automatically become the one that they had in mind. No.
No, but now I'm just looking at Section 194 as a whole.
Yeah.
It envisages a situation where there is a committee of the National Assembly which makes a finding.
Yeah.
Now that's the
one that's sitting.
Yes. And that's the only committee that the section talks about.
Well, my lord, tough luck. If that's the only committee, but 194.3a envisaged another one, then that's not our business.
But that's not how you interpret the Constitution. Otherwise, you make it unworkable. So if there is an interpretation that would enable the provision to be workable, you prefer that interpretation.
Yes, but workable against the rights of a person? No, you can't, my lord. You can't.
Because on your submission, the proceedings could never start.
No.
Could never commence because the Constitution is silent on the committee for the removal.
No, my lord. Let me try and explain this. It's this, my lord. What? The question you must ask, you can't say the 194.3a envisages a committee. Therefore, we just look around and say, well, is there a committee in any room here? Say, yeah, then it must be that one that was envisaged. No. The question is the other way around. What is the committee that the framers of the Constitution had in mind when they wrote 194.3a? Full stop. The second question is the one that you and I are debating now, my lord, whether that committee is the same one as the one envisaged in 194.1a. That's a matter of serious interpretation, and I will demonstrate that the answer to both of those questions is no. And I do it like this, my lord. If you could look at 194, put it this way, unfortunately, the reason, I can give you a brief history of how this came about. We did a case called EFF impeachment case, where Chapter J gave the majority judgment. I'm sure your lordships have read it. And we were making this very point, and fortunately the majority agreed with us. We said you cannot have an impeachment, in that case of a president, without rules that define each step. Then Parliament, around about 2019, then literally copied the rules that were as a product of that case and adapted them for this purpose. That's important because when they did that in 2019, the question is whether they were answering the question that was posed by the framers of the Constitution. We'll put it this way, my lord. Parliament, we know that is free, it can do whatever it wants. It's an arm of government. So the Parliament could have said, for example, it could have put 10 committees, if it likes, before you get impeached. And say the other one is going to be called the impeachment committee, the other one is going to be called the appeal committee, the other one is going to be called... Parliament is free to do whatever it wants. This idea that if there's one committee, therefore it must be that one. It doesn't work. Because Parliament could have said, for example, once this committee that's sitting now finishes its work, it will take that work to another committee called a removal committee, which will process the removal process, take it to the president and what have you. Nobody would have said, why are you doing that, Parliament? Because Parliament would say, we're doing that to ensure that there is fairness. Now, here's the thing, Justice Nook. Look at 194.1. B, yeah. Public Protector, the Auditor General, a member of the Commission established by this chapter may be removed from office only on A, the ground of misconduct, incapacity and incompetence. B, a finding of a committee of the National Assembly. It doesn't say a committee of the National Assembly for the removal of the person. Now, one of the most basic rules of interpretation is that the framers of a statute, let alone a constitution, even worse, don't just put words just for fun. So when the committee is described in 194.3a as the committee for the removal of that person, what is the significance of that? Why is the one in 194.1a just called a committee of the National Assembly? And as I say, it's common cause that is not a removal committee. That's a committee for to make a finding of guilt or otherwise. There's no debate about that. But in 194.3a, they make it clear. And they don't say the committee that we refer to in 194.1a. They say a committee for the removal of the person. In my respectful submission, there is no doubt, there can be no doubt that that is another committee that was envisaged there.
So just so that I understand the argument on this point.
Yes.
Because I understood initially in respect of Part A, the argument seemed to have been that commencement, at least you must have evidence leaders, you must
I'm
start with the evidence. So that is not what we should be concerned with.
No, it is Justice.
It's not the same argument that we are making.
No, it's not the same argument. I've just said that that's why I was saying, let me start by declaring that was the argument in Part A.
But that's not the argument before us. That's
it
all
is.
I want.
It's an alternative argument. It's not abandoned. I'm saying we introduced an argument here, which I just read out, that whether the current process does not yet constitute removal proceedings.
Because there is no committee as envisaged in section 1943A.
No.
Is that no, I'm just trying to understand.
Just to understand the argument. Yes. No, it's the other way around. It's because the committee that is sitting is not a removal committee. That's the easier way to understand.
The other way of saying that there is because there is no committee that is contemplated in section 193A.
Yes, there isn't.
There is currently no. So those proceedings for a committee that does not exist could not have commenced.
Natural.
So that's the
okay.
argument.
No, I understand you, Justice Nook. That's where I'm going. In other words, I'm saying that if we accept that, the simple point is to say 194.3a envisages something called a removal committee. A, tick. Everyone will agree with that. The question is the committee that is taking place now a removal committee? No. And if I am right in both of those, just finish, Justice Francis. If I'm right in both of those propositions, then the question is not, as I say, okay, well then now we've run out of a committee, let's find one. The question is whether the committee that is sitting can be described properly, fairly, constitutionally as a removal committee or not. And then someone who says that is so will then have to explain why the drafters of the Constitution said in 194.1 you must have a committee. And then, but in 194.3a say a committee for removal. and qualified it now this time to say a committee for removal. And that is only in aid of one thing, Justice Nuku. It is not, Parliament will do whatever they need to do, if whatever the implication. The function of this court is is a simpler one. It is whether the proceedings in 194.3a have started or not. That's all. What the implications and all that, that's not for this court. That's for Parliament to deal with. If the answer to the question whether the removal proceedings have started is no, then that's it. Sorry, I want to make the next point, but I know Justice Francis wanted to ask me a question.
Thank you. Section 194 is headed removal from office.
Right.
So we know sections 194, 1 to 3 all deal with the removal from office or possible removal from office, because it doesn't have to end up in the removal. And that is why I think 194.1 says may remove.
Yes.
Okay. Now, 191B says a finding to the effect by a committee of the National Assembly. So that committee appointed by the National Assembly will merely make a finding as to whether there should be a removal or not.
Yes.
Merely a finding on the basis of the evidence that might be laid before that committee. Okay. So, it's, as I understand the process, if you read the rules together with the Constitution, it's the National Assembly. Well, firstly, there's obviously going to be a motion to say that.
Absolutely. To
initiate. The Speaker looks at the matter, it goes to the National Assembly, a panel is then appointed. That panel then makes a prima facie case. And that's where we are with 1A, because that's where the prima facie. Once that's done, then a committee is established to actually conduct a formal inquiry. Okay? And make its findings and then refer it to the National Assembly, who will then take a decision. Okay, that's where we are.
Yes.
Right, that's the process.
Thank you.
And that process is described from 94.1 to 94.3. You see, sorry, if you just allow me just to develop this. The committee referred to in 194.1b can only be the committee that's referred to in 194.3a. There's no other committee. The term removal of that person, I don't think there's any magic to it. It merely just said it's part of the process described in 194 merely for the removal. That committee itself doesn't have to decide on the removal. So I think, as you pointed out, I'll just put it to you, that right at the opening of your address, context matters.
Absolutely.
So we need to look at the context within which reference is made to of the removal. And that context doesn't mean that committee will determine, merely has to make a finding, which will then be fed to the National Assembly.
Yes. Then I don't know the meaning of the words a committee for the removal of a person. Then it means there's no such, these people were just, I don't know what
it could also mean a committee engaged with Section 194 inquiry for the removal of.
No. So, yes, it could mean that. But I'm saying, Justice, and let me take one step back so that I can show you the reason, because we talk about purposive interpretation. The purpose of these things, Justices, is the starting point is that a suspension is something that is prima facie burdensome and an invasion of the rights of a person. This is it's probably one of the most fundamental flaws of the judgment in Part A. It's actually one that offends the sensibilities of any constitutionalist that should. And it goes back to what we were debating here earlier. This idea that suspending the public protector is suspending an office, some inanimate thing that has no feelings, has no dignity, has no is just an office. That's what that judgment says. Why should we worry about, there are no rights of heirs that are infringed because it's the office of the public protector that is here. There's no such thing, Justices. There's no such thing. That problem starts here. And this judgment, quite frankly, once you get this point, then you'll realize that there is nothing that can be put into this judgment. They say in paragraph 77, which is, you'll find it 234. Says here, the applicant on the papers is the Office of the Public Protector. Now, I've just shown, all you have to do is to pick up any volume of this and see where does that come from. The applicant is not the Office of the Public Protector. And then it says, Advocate Mkhwebane is different from the Public Protector. This may
At least
seem,
that part seems to be right. That she's different from the office.
She is, definitely, but once you are wrong on the first one, you are gone. Because if you say the applicant on the papers is the Office of the Public Protector, whatever you say, which may be right after that, is irrelevant. Because, and this is where they miss the boat with the greatest respect, because, and this is crucial. Once you miss that point, that actually what is here is a human being with feelings, with dignity, then you go to what we say in our heads, in the Part A heads. You'll remember we've explained the, at page 68 of the bundle of heads.
Your Part A heads.
Part A heads, which are attached to the Part B heads. Page 68, my lord.
The page or paragraph? 68 is the...
Page 68, paragraph 80, 80.
My page 68, there is only the list of authorities.
Okay, then it means the number... All right, paragraph 80, 80. It means that there's something wrong with the numbering.
Paragraph 80.
80, my lord. If you miss this
yes,
point...
that's the one that were, yes. I think it talks to the point that you're talking about.
Yes, absolutely. Thank you, madam. And this, with the greatest respect, whichever way we try to explain it to the Part A court, it just didn't register the way we wanted it to. And that's why there was this thing about the applicant is the Office of the Public Protector. We said it's indisputable as a general rule that any suspension from work limits the suspendee's rights to dignity, reputation, and work. It has been correctly observed, and that's now by a lower court, and I will show you that all our courts have made the same point. This was the labor court. It has observed that suspension is the employment equivalent of arrest, with the consequences that an employee suffers palpable prejudice to reputation, advancement, and fulfillment. As if that was not enough, the SCA made the point even clearer. Newton J.A. said in the Wachenuka case, the freedom to engage in productive work, even where that is not required to survive, is indeed an important component of human dignity. For mankind is preeminently a social species with an instinct of meaningful association. Self-esteem and the sense of self-worth, the fulfillment of what it is to be human, is most often bound up with being accepted as socially useful. But the Constitutional Court put it beautifully per subs A. in the paragraph 8.
We must use your time productively because we're going to hold you to it. There's
Yes.
still a number of issues that you still have to address.
No, my lord, this is, if we miss this point, as I say, we might as well go
I think that point is well made.
Okay.
In the,
Yes. Now, and what the Sachs J said, I'll paraphrase then, is simply that it says fairness to an incumbent about to be relieved of a high-profile position in public life presupposes the display of appropriate concern for the reputational consequences. People do not live by bread alone. In other words, the fact that you are on paid suspension doesn't mean that you are not being paid. That's where this whole problem comes from. If you miss that point, then you will miss the point that Section 194.3a, because it imposes a suspension, by implication must also afford protections to the victim, so to speak. Now, if you look at 194.3a then with the eyes of a protective measure rather than an attacking spear, look at it as a shield for the victim, then the entire picture changes. Because what that section then says is that, and this is not a small matter, this is a matter that is related to the independence of the institution. That is why judges cannot just be suspended willy-nilly, because you have to protect them from, you have to protect their independence. That is why judges have a security of tenure. That is why the public protector has security of tenure. This principle was discussed ad nauseum in the case of Corruption Watch, which is in our heads, in relation to a DPP, Director of Public Prosecutions. This measure, my lords, as I say, if you put the glasses off that this is just to suspend and get rid of you, then you'll come with one outcome. But if you put the glasses that says this is a measure to protect the independence of these institutions, and we go back to the certification case. Remember, in the certification case, the original constitution said a public protector can be removed with 50% of the vote, and an auditor general. But that court said no. The Constitutional Court said no. We have to protect the independence of these offices. Let's increase the threshold to 2/3. Why did they do that? To protect the incumbents from abuse because these are offices, as Mkhwebane CJ said, which investigate powerful people. So they have to be protected. Now, then if you look at it like that, it becomes very simple. The Constitution, therefore, wanted to put the point at which a public protector can be suspended at the latest possible time. And where is that time? When there's a finding that that person is to be removed. Because before that, there is no removal process. And this is exactly why...
Would that be now after the proceedings of the Section 194?
Of the 194.1 committee, yes. Once the Section 194.1 committee goes nay or yea, then the whole thing then becomes a removal process.
But now all that's left is for the National Assembly to vote on the motion.
It might well be, but remember, the founders of the Constitution did not know what rules are going to be drafted in 2019. Okay, so it's the National Assembly's baby to have structured their business in such a way that it conforms with the Constitution. It's not the business of the court. The only point I'm making is that the court must accept that when the Constitution said after a particular point, then you can be suspended. You cannot then suspend someone before that point has been reached. And that is why, if you go to, you see, this idea of using values to get an outcome that a predetermined outcome on interpretation is wrong. It's just wrong. And that's why, if you look at page Okay, just the front page of those heads, paragraph 1 of the Part A heads. We put the following preamble, and we were putting it, we were hoping it was going to make the impact. As I say, it didn't. It says, you see, the problem is that people use values, and values, you say, no, I'm using accountability. And then we must forget about dignity because we are now using accountability. Then we must forget about equality. Then we must forget about transparency. Then we must forget about openness. Then we must forget about the supremacy of the Constitution. Then we must forget about the rule of law and just flag one value. And this is what Cambridge AJ said about that. The Constitution does not mean whatever we might wish it to mean. Let me pause there. So the Constitution doesn't mean, if you say, yeah, it makes sense that you should be suspended at a particular point. No, it's not what we wish for it to mean. It says, even a constitution is a legal instrument, the language of which must be respected. If the language of the lawgiver is ignored in favor of a general resort to values, the result is not interpretation, but divination. In other words, you are just being prophets and doing philanthropic acts. But this is not about interpretation, is about being bound by the words of the Constitution. And if the Constitution says a committee for removal, you can't then turn a committee that is not for removal into a committee for removal just because it would be a nice thing for it to be like that. So that's the first point. If we are wrong about that, and somehow the committee can just be squeezed into a removal committee, despite its own denial of that, then that's fine. Then we then go to the position of the position, which is this. Again, it goes back to interpretation. We say that when let me put it like this. It's actually simpler if I put it like this. How can, and I made this example, I think, in the previous court. Just think of the Zondo Commission or any commission you like. Marikana Commission, whatever.
Sorry, just before you get to this part, my reading of the paragraph that you referred to does not seem to raise this issue that this committee is not the committee envisaged in section 1943.
No, it raises a more fundamental point.
No, what I'm saying is on the papers, it doesn't seem to have raised that. I hear what you are saying in court, but it doesn't seem to be contained in the, because all that the deponent says that there is no new matters. I rely on the submissions I've made in respect of Part A.
No, my Lord, I'm so sorry.
So I'm saying,
paragraph 61 and 62. 60, 61 and 62. I even say in my head, I don't understand why nobody has responded to this. I think even in the reply, we make this point, my Lord. So that one...
say that in respect of the ground of illegality relating to the interpretation of section 1943A,
yes,
and more specifically, whether the removal proceedings envisaged in that section have indeed started, there are no new material facts, and I intend to rely on amendments
yes,
made in bundle.
On the facts, yes.
So nothing new there.
Facts.
So you don't raise the point that you are raising there.
Just read on the next one, my Lord.
The suspension is clearly ultra vires because the proceeding envisaged in section 1943A, when properly interpreted, have not yet started, had not started on the 17th of March, and in any event, the current process does not yet constitute. All right, I see.
Thank you very much.
Thank you.
So the point is pleaded squarely and is unanswered. That's probably why you forgot about it, my Lord, because there's no one who
There's no engagement with
yes, and we even probe it again, I think, in the reply, and then even in the heads, and yet there are no takers. And so it's an unanswerable point, to be honest.
It is not approved that there's only one committee that existed. Did they not assume that there's only one committee that is being envisaged in section 194?
Yes, they must have, but the point I was making, Justice Lukulin, was exactly, it's not so much about committees really, it's about the proceedings. Are the proceedings, because remember the emphasis in section 194 is the proceedings. After, and the word after is also instructive, after the start of the proceedings of a removal committee. So you must satisfy all those three. Is it after the start of the proceedings of a removal committee? So it's quite clear. But I'm saying let's move to the alternative argument very quickly. And that one I'm going to save time. I'll just I was busy with that. Justice Niku, I'm glad you raised this question about whether it's pleaded because yeah. So where I was saying let's take any committee, Security Commission, whatever. If you went out of the street here into a taxi rank and say to somebody, that commission has started before there are terms of reference, before there are evidence leaders, before the person who's being investigated is even notified. They would say, Mr. Bofu, you are smoking something. What are you talking about? How can you say that such a thing has started? I mean, it's common cause that evidence leaders were appointed somewhere between the 22nd and 29th of March. They were introduced for the first time on the 29th of March. So how on earth can you say that that committee, assuming now for the purpose of this is the same committee, how on earth can you say that it has started? In a statute, or rather a constitution, once you understand that this is a protective measure of the independence of the public protector, then your interpretation must be in favorem libertatis. In other words, it must be in favor of the individual. Just as that saying that says the suspension is the employment equivalent of arrest. It's exactly that. Because when you arrest someone, immediately you are invading their rights. And you are restricting their movement and so on and so on. So nobody can say you are not affecting their constitutional rights. The question is whether there's a justification. Now here's a situation here where this court, which is where we were, the court in Part A, then says that at, I think it's 230, yes. It says at 95, 239, sorry. At this proceeding, we remove the applicant. At this stage, sorry, he only has power to suspend after the first respondent commences proceedings to remove the applicant. As I've said, those proceedings have not started, have not happened on anybody's version, proceedings to remove the applicant. So, and then says, at this stage, there will already, as a matter of necessity, have been levied credible allegations of misconduct, incapacity, or incompetence against the employer. Regrettably, this is precisely what we are dealing with in this matter. In other words, as soon as credible allegations are levied, then you can suspend. Surely that must be wrong. Because that point, when the so-called credible allegations of misconduct were levied, was right at the beginning, when Ms. Mazoni put her motion, and then the Speaker found that it was in order at worst for them. At best for them, it was at the point at which the independent panel said there's a prima facie case. That's again credible. Then why do they wait for 2 years to suspend, if indeed the mere levying of credible allegations which happened in February 2021, my lords, was the point. But as if that's not enough, the court then contradicts itself at 109. At 109, they then say, at the time when the matter is referred, oh, by the way, the big point is that if this point, the first point that we've just debated now, was not decided by the earlier court, then obviously it can be stare decisis, just for obvious reasons, because that point was not before them. So so if I'm right on that point, the whole thing about stare decisis just flies out of the window. Okay, so they say at 109, at the time when the matter is referred to the impeachment inquiry committee, a line falls to be drawn in the sand, and there can be no doubt that the complaints against Advocate Mkhwebane are serious and could result in a removal. This is precisely when the power to suspend is triggered. So now suddenly, precisely, it's completely something else to what they said in 85. So now it's at the point when the matter is referred to the impeachment inquiry committee. It begs the first question, do we have an impeachment inquiry committee now? No, or a removal. Remember, Chapter J said impeachment is just a synonym for removal. And so it raises the first point, but it says a line falls to be drawn, and then there can be no doubt, blah, blah, blah. That means then it's, again, it's the 16th of March. But go to 120 now. They say, even if a liberal interpretation was given to the concept of the proceedings of the committee, undoubtedly the proceedings started when the committee met on the 22nd of April 2022. Firstly, there was no such meeting. It just doesn't exist.
As a matter of fact.
As a matter of fact.
It was 20 July or something, was it?
Yeah, 20 July 2021.
2021.
No, let me explain where I think the mistake happens. On the 22nd of April 2022, there was the so-called Audi 1.
Audi 1.
Yes, letter. So, but there's no meeting. I'm just simply saying it's just factually incorrect. But let us put that aside and say that they want to refer to the letter, not a meeting. Let's be generous. The point is that on the 22nd of April, all that happened was that a letter was written to say to us, let's respond and so on. So how can that be the start of the proceedings? I mean, on any interpretation. But let's assume it is for a minute. How does that help the respondents? Because the suspension proceedings were triggered on the 17th of March. So then it means we must just go home. Then the public protector must be reinstated. Because it means the president triggered, on this version of this court, triggered the suspension process a month and 5 days before the proceedings started. By the time we go to the July version, then it becomes even more ridiculous. Or because that would then mean that by the 9th, when they actually then did suspend, I'm sure the court follows that it just gets worse. But go to 123 when you think it cannot get worse. 123.
But to be fair to the court, Mr. Boff, it seems there that they are saying, well, you could look at it this way. It's not a contradiction, but it's just
a suggestion.
At most favorable to the applicant. You could look at it this way.
Yes. Well, well, then it's not binding. If it's just a suggestion, because you can't have it both ways. You can't. If it's a ratio decidendi, then it's binding. But
it doesn't look like the
yeah. Well, what is the ratio decidendi on this point? That's the point. There isn't. And then we go to 123. It says significantly the process is okay before any evidence is tendered or any charges are formal charged. As a matter of law, it must be so that the third respondent is vested with the requisite power to initiate the suspension proceeding against Mkhwebane when the Section 194 committee commences with its work. The new version now. Work. So the Constitution, I mean, do we think the constitutional drafters did not know that the committee will do its work? If they wanted it to be the point of suspension, they would have said so. They wouldn't have said the start of the proceedings for the removal committee. And this is where, with respect, we say that court is not allowed, with the greatest respect, to rewrite the Constitution. If the Constitution says it's the point of the proceedings is after the removal proceedings have started, even if we assume for the purposes of this debate that it's the same committee, then it must be the start of the actual proceedings, which at the worst or at best for us would be on the 11th of July, when the proceedings started just down the road. And therefore, on all these versions, the kick-starting of the suspension on the 17th, or the actual suspension itself on the 9th, were premature. And the law works like this. The rule of law says that one of the ways in which what you cannot do is to write your own rules as the decision maker now. So as a decision maker, you have to apply your mind very carefully as to what it is that you are allowed to do in law. And that has two implications for the president. One, it is that it is, well, he abdicated his responsibility. It goes to the question of the letter. Because he says, well, that's what the speaker said. So, but it doesn't work like that. He has a constitutional responsibility to satisfy himself. When did the proceedings in this stage in 194.3a start? If he can't answer that question, he cannot then act to the adverse effect of another human being. He's not allowed. The Constitution does not allow you to do things like that. And just, you have to satisfy yourself, particularly when you are going to use arrest powers, and I'm using that in quotes, when you're going to use such drastic powers that invade somebody else's rights. That's what our Constitution is all about. It's to protect the rights of the weaker party in the equation, not the powerful party. The powerful party must restrict himself or herself to that which is allowed in the Constitution. You can't protect the powerful. Otherwise, why do we don't need a Constitution? The powerful can protect themselves with guns and all sorts of things. The Constitution is there to protect the victims of such suspensions. And if the court is on 50-50 on this, the court must interpret the Constitution generously and purposively in light of the independence of the office. Last point I want to make is an analogy.
Sorry, before you
I'm
go
sorry.
on to
Yes.
I think the points you make are certainly listening with some attention
Thank
to
you,
it.
thank you, Justice.
And in the sense, courts are in an uncharted territory because
Absolutely.
this is really the first time it's happened. And unfortunately, we know, or we can assume that the public protector is not your normal employee. He's not a normal contractor. However, in the Constitution, the term suspend is used. And in a normal parlance, suspension is there for a particular purpose. And one of those purposes is to preserve evidence, to preserve the integrity of witnesses, and so on. And that seems to be also something that one needs to take into account. But there's another aspect, because the public protector is not your normal employee, and that's to protect the organization. That's also an important factor.
No,
so while I hear you saying that the Constitution is there to protect advocate and fund, and there's no doubt about that, one can't quibble about that, but there's also another element, and that's protecting the institution.
Absolutely.
So once a prima facie case has been made out that the incumbent has engaged or possibly engaged in acts or conduct which is very serious and may well lead to a removal, surely then there's an imperative to in fact protect the organization.
Yes.
Okay. Now, if the organization should be protected, it must be done sooner rather than later. Now, if I understand your argument, the main argument now on this issue, it's that the removal process would only take place once there's a removal committee that makes a determination. And to my brother's comment here, that would be just immediately before the National Assembly takes a vote. That may be like months before a prima facie case has already been made out. So if one combines the normal rules for why an employee, and I use it in air quotes, is suspended, together with the need to protect the organization, surely it means then that suspension must come quite early on in the process.
No. That's completely, with the greatest respect, Justice Francis, what you call it, subversion of our Constitution. Because, and that is, in fact, it ties up, with the greatest respect, Justice Francis, with the point I was about to make. And I'll answer it that way. Okay, purposive means you have to really put yourself in the, and that's why I'm giving you the history of the 2/3, why it was heightened and so on. The purpose of all that was to protect the, not the organization, but to protect the incumbents, right? The incumbent is being protected for a particular reason, Justice Francis. And it is that is said in the EFF Nkanka case, where Justice Mkhwebane says she is the biblical David against the Goliath and all sorts of, all the raw chambers of power and what have you. She has to touch the most powerful people in society, and therefore she must be protected. That's what, when the certification court case was being decided, they were not, it's not like, of course they had to protect the institution. That's why they could have said it must be 100% threshold, but they had to 75%. But the real intention was to protect the person. Human rights, human. She's a human person, and she must be protected against any invasion of her rights. That's the issue. That's why this thing about arrest is exactly on point. Because again, you can say, no, this is a criminal, they've killed 1,000 people and so on. But you may not arrest them, or you might keep them for 48 hours and so on and so on and so on. All those things are not just for people who are petty criminals. They are for the most heinous. Why? Because they are human. That's the only reason why we have to protect them. So the organization, yes, has to be protected. And that's why I was talking about judges. In the case of judges, if you look at section 177 of the Constitution, it becomes much clearer. Incompetent or is guilty of misconduct. That is the equivalent of what you call the section 194(1) stage. There must be a finding. And then it says the National Assembly calls for a judge to be removed, blah, 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 adopting, supporting 2/3, same thing. President must remove a judge from office upon adoption of a resolution calling for that judge to be removed. So the removal process only starts what we call in the JSC, the JCT, the Justice Conduct Tribunal. Justice Francis makes a finding. Then it's moved to Parliament. Why is that? Otherwise, they would have said what you're saying. No, as soon as the JCC, which is the Justice Conduct Committee, finds that there's a prima facie case and the case may be moved to the JCT, the public must be protected, or the institution or the organization or whatever. No, you still can go another 2 years in the JCT process before you can be suspended. Why? Because you have to protect the independence of the judiciary. There is a reason why section 181(3) of the Constitution reads exactly as section 165(3). Both those sections, you can transpose them almost literally. 165.3 says, organs of state, through legislation and other measures, must assist, protect the courts to ensure the independence, impartiality, dignity, accessibility, effectiveness of the courts. 181.3 is a mirror image. It says, other organs of state, through legislation and other measures, must assist and protect these institutions to ensure the independence, impartiality, dignity, and effectiveness of these institutions. That is why the public protector is the only institution in the world, not in the world, in the country, that is protected by contempt. Section 9 of the Public Protector Act says that the public protector, if you insult the public protector, you must go to jail, just as if you are insulting a judge. That doesn't apply to any other institution in South Africa. Because, why? The obsession, if you like, with the greatest respect, of the founders of the Constitution was to protect the independence of human beings, not buildings or offices or organizations or inanimate objects like that, while that is also important. And that's why a judge must be protected until quite late, as opposed to quite early, as you suggest, Justice. It's the exact opposite, to make it as late as possible, so that by that time we are almost only left, as Justice Snook was saying, at that point you are only left with the matter just going to Parliament, and then you can suspend. But you can't do it before that.
Why suspend it all then?
I don't know. That's
the whole point.
No, but
words are used in the statute for a reason. You just can't ignore them.
The word suspend, when it's used in this statute, must mean only one thing, which is to deprive you of your right to work and your right to perform your judicial functions if you are a judge, or your right to perform your Chapter 9. It can only mean that. So there's no magic in this. There's nothing mysterious about what it means to suspend. The question is, when does the Constitution say we must suspend? That's all. If the Constitution says we must suspend at the latest possible point when we are double sure, that's what it says. I don't know. I can't ask them why. Why did you? Why? Because logically, it might make sense that as soon as somebody says, "I just saw Judge so and so in Kimberley taking a brown envelope," surely, at a logical sense, that should be the guillotine must fall, and you say that person cannot be on the bench. I understand that, but unfortunately, that's why we say this is not divination; it's interpretation. You don't do what seems to be logical. You do what the constitutional writers said must be done. Whether they are wrong, well, that's a matter for Parliament. You can amend the Constitution.
So what I'm just saying to you that because the term suspension is used in that section,
yes,
it must mean something.
Yes.
And there must be some reference point for this court to look at.
Correct.
As to why there's a need. So it's not just the how,
yeah,
it is the why.
Yes. No, I accept that 100%, Justice Francis. That's why I gave you a reference point. Because another rule of the canon of interpretation is that when a word is used in the same statute, it must mean the same thing. That's why I took to section 177. Because the word suspend there must mean the same thing that it means in 193A. And so that's exactly the point.
But there in section 1, sorry to interrupt you, but in section 177, it does not say that the suspension must only occur once a finding has been made. Just as on the advice of the JSC.
No. Let me explain how. That's exactly the point, Justice Snook. That the JSC. Let me explain how it works there.
And just so that we can also cover this point, it does seem to me that there are instances where that happens way before even the tribunal is set.
No, Justice, it can't. It's impossible. Let me explain. The JSC, there's something called the small JSC. And I'll explain what it means. What it means is the JSC sitting without the parliamentarians. Okay? not the National Assembly people, because they would be conflicted if they were, when it comes to the 2/3 vote. So once the matter comes from the JCT, it then goes to the so-called small JSC, and that is what is meant in section 177(1). Only after that body has set, and as a matter of fact, I think it's sitting today. Once that matter, once the JSC, the small JSC sits, at that point, then the matter is referred to Parliament. Why?
No. That's isn't that the stage where the matter can be referred to the tribunal?
No, the JCT means the tribunal. That's the point I'm making. The JCT is the equivalent of what is happening down the road.
Yeah.
Okay. So the only once that finding has been made by the JCT, does the so-called small JSC. Otherwise, it can't meet for what? It only meets there when, because there are three. In that case, remember, there's gross misconduct, there's misconduct, and what have you. So once a finding of gross misconduct has been made by the JCT, which is the tribunal you are referring to, only then can the JSC even have a meeting to refer the matter to Parliament. And once that happens, then the suspension is competent.
But why do I get the impression that there are judicial officers that may have been suspended prior to the determination of their...
No, but that's not... No, but that's not...
it seems to go against what you are suggesting, because that doesn't seem to be consistent with that. I don't want to refer to specific cases, but I'm sure you can think of...
I know, Justice.
Yes.
I know what you're
So
talking
it
about.
does not seem to support your submission that you must wait until the latest when there's been a determination.
No, Justice. The cases you're talking about have got nothing to do with impeachment. Okay. That's the problem. Those cases, we are talking about impeachment, removal. Okay. A suspension in the context of a removal. Justice Francis, both of those sections, you'll see 177, the heading says removal of a judge, and as was pointed out. So let's not conflate the issues around what might happen, in another context. That's not where we are. I'm saying...
No, I'm raising it because
right.
you want to you are referring us to that section so that we can look at how it's dealt with.
Yes.
And say, well, it must mean the same thing.
Okay.
So I'm raising that in that context.
No, I hear you, Justice Mills. Let me give you a shortcut. When the court, in its own time, is considering the matter, please just go into the JSC Act. What I'm saying will be very clear. What happens when, up to, I think, Section 23, and when is a suspension competent. I can't take it further than that. Now, if as I say, even at the colloquial level, if we all accept that the proceedings cannot start, for example, before the evidence leaders are in place, all the things that we've listed in some paragraph, then it means, again, it goes back to Justice Francis's point. Do you take the hawkish approach to say, as soon as it looks like there might be problems, let's suspend? Or do you take the proper constitutional approach which says you must do it only as late as possible when there is a finding of... and it's a matter of interpretation. It's not a matter of... It's not a choice that the court has. The court is enjoined to interpret a constitution purposively and contextually. There's no two ways about it. So even if the court might say, but what about this, what about that? The Constitution says what it says. It doesn't say what we want it to mean. It says what it says. Right. Now then, can I move to the conflict point?
Yes, so just before we move, so your point about the interpretation of Section 1943 deals with the conduct of the Speaker, deals with the conduct of the President, deals with the conduct of the chairperson of the committee.
Absolutely.
So that you don't need to go there in detail because...
Yes, let me round off that point. You're quite right, Justice Smith. It deals with, yes, because it's again, I like your word, domino effect. For the domino effect of that, just to round off that point, so that we don't have to go back to it. The domino effect of that is this, that all of this, if I'm right on my first point about removal committee, then of course the whole thing just flies away. But on this alternative basis, assuming the committee is the same committee, then the domino effect is this, Justice Smith, that when the Speaker said, remember the Speaker, it's even worse. The only person really who has been sensible in all this is the Deputy Speaker. And I'll deal with that maybe in reply. But the Speaker, as an office, said on the 21st of July, 2021, wrote a letter to the President saying, and that's another giveaway, the proceedings will commence. So will, we all know, we learned this at grade 3. Will means it will commence in the future, not now. It will commence. That even adds more to the confusion. The same Speaker then writes on the 10th of March, without saying when did that thing that was going to happen actually happen. Say, they met again on the 22nd of February. Remember, there was that suspension, voluntary suspension of the process. And that's another source of confusion. They confuse process and proceedings, but that's another story. So the process, yes, was suspended, but that doesn't mean the proceedings of a committee for the removal of the person were suspended. That's a completely different thing. Then the President acts on the wrong advice of the Speaker, because the Speaker has caused the confusion that I've just explained. Where you don't know, she says, she even attaches the letter of the 21st of July to the President now on the 10th of March. It's complete chaos. And the President, on the basis of all these bits and pieces, says, aha, here we go. Show me why I should not suspend you. But by cobbling up all these broken pieces. So you're quite right, Justice Nobu. The mischief contained in the letter stems from the fact that, as we said earlier in the morning, stems from the fact that the information in it was legally wrong. But yet it triggered all these other things. And you're quite right, the activities of the chairperson of the committee is the same. And this is a question, I can't remember which justice asked me this, I think it was Justice Moore. It's important to say, this was not like the Speaker was somewhere writing a letter. No. In February, we write to her. We say, there is a process that is taking place in the Constitutional Court. Please don't convene the committee. She knows this. She says to us, writes to us to say, please give us the grounds on which you are, to show that they're taking this seriously. So if you give us the grounds of what you are raising in the Constitution, we do it. In fact, I remember this as if it was yesterday. That letter came in the morning and they said, give us the grounds by 1 o'clock. We had to drop everything. And 1 o'clock, we gave them the grounds of the rescission. And then we said that is going to be done within the space of 10 days. I can't remember if it was 10 or 15 days. That 15 days was ending on the 11th of March. She knew this. And then on the 10th of March, she quickly writes the letter to trigger the President to suspend. What is that? How can that, on the basis of no powers that we know, no provision in the rules that says she must do such a thing, and knowing, that's why context is important. It's not like the Speaker just woke up and wrote that letter. She knew that there were proceedings that are dealing with this very issue. So it was that conduct. Is that conduct consistent with the Constitution? No, it's not. A reasonable Speaker in her position would not have written that letter, would not have done so under those circumstances. Is the conduct of the President in writing the letter of the 17th consistent with the Constitution? No, because he abdicated his powers against the principle which is set out in SARFU to the Speaker. He is the decision maker. He's the suspender. He can't say, no, I just got a letter and therefore what do you expect me to do? No, it doesn't work like that. So his conduct as well is unconstitutional. And so on. And then by the time it comes to the 9th, which takes us to my next point.
Sorry, before you go.
Sorry, yes, sir.
Now, what should the President have done? He gets a letter saying, proceedings have commenced.
Yes.
Must he now go behind that letter and investigate?
Of course. That's exactly the point, Justice Francis. It's a crucial point that you're asking me. The Sarfu case says that you cannot, as a decision maker, you can't, it's called passing the buck or abdication in administrative law. I think it's page 465 of this book. It says that a decision maker, sorry, passing the buck. It's quoted in our heads, in our party heads. Sorry, Justice. Yes.
But the short point being that it was for the President to establish whether the jurisdictional requirements are met before he can exercise that power, because otherwise he might be exercising it not lawfully.
Yes, if anyone, I can write a letter now and say, President, Lesotho is invading us. And then he says, looks at the letter and says, oh, let's send the army. Without satisfying himself that which is in the letter, how can that be a constitutional exercise of such important power?
My question was directed more at the nature of the inquiry that needs to be done.
Yes.
I can imagine about Lesotho being invaded, because that's quite serious,
and
you'll have to do that. But in this case, the Speaker, the one who is to look at the person who's conveying the message, the letter says officially, proceedings have started. What more of an inquiry is required, and that's what I'm asking.
The test is subjective, rather it's objective. It's not subjective. So that question cannot be asked like that. The question is, objectively speaking, are the what we call the jurisdictional facts for me as a president to act present, yes or no? For that, you have to satisfy yourself. You have a duty, a constitutional duty, to satisfy yourself that the jurisdictional powers to act, when you are a single actor, it's not like the cabinet or the president. It can never be correct to say, well, what must I do? There's a letter here that says it's like that, therefore it must be like that. It doesn't matter. That's exactly what abdication is. And this is what it says. There are a number of well-recognized ways in which one administrator may abdicate. That's paragraph 109 of our party head. May abdicate power while another usurps it. In other words, the president was abdicating the power and the speaker was usurping it. The most common of these, and certainly the most in practice, is the unlawful transfer or delegation of power. In other words, you unlawfully delegate that which is your function to satisfy yourself to somebody else to do. Another is acting under dictation, and the third is unlawful referral or passing the buck. The last two are so closely related to be indistinguishable in some cases, and indeed nothing turns on the diagnosis, and then it goes on. And that was explained in Sarfu. Yeah. No, it's the same. In Sarfu, I think it's paragraph 171 of Sarfu. It says, it answers your question, Justice Francis. It says, it doesn't matter what the president's view is. Because remember, yeah, you'll find that at 102 of our Part A head. The legally relevant question is not whether the President thought that the subject matter of the inquiry was a matter of public concern. That was the jurisdictional fact there. But whether it was objectively so at the time the decision was taken. Whether or not the matter is one of public concern is a question for the courts to determine, and not a matter to be decided by the President within his own decision. So it's for the court sitting here, not for the President to say, well, I got a letter and I did it. And even if you can say, let's say, Justice Francis, the President could show that, look, I was actually rushing to the US and somebody gave me this letter and therefore I just read the first paragraph and the second paragraph. So on the facts, you might find that there was a justification subjectively in a particular way for him not to satisfy himself. But that's not the test. The test is that objectively a president, Noha, cannot just say, I just pressed the nuclear button, because someone said so. You are given so much big powers as a president that should be directly proportional to the care with which you exercise them, because they are big and drastic powers. It's not like me and my learned friend. You have power to press the red button and kill the whole world by just pressing a nuclear button. And then you say, oh, well, what was I going to do? I just got a phone call. No.
Just to correct myself earlier on, Mr. Mbofo, I said that section 1943 deals with 3 actors. It seems to be 2.
Yes.
The committee is related to the pending decision.
Absolutely. No, that's correct. Thank you. Yes. But it reinforces the point you made earlier of the domino effect, because the 1943A literally deals with all 3 of the main respondents. It deals with the committee, deals with the president, and it deals with the National Assembly. In other words,
but I'm saying that the issue raised there is the impediment. It relates to the Rule 89,
yes,
and the fact that there is a pending
decision. Yes, that's correct.
Because it's not concerned with the commencement issue, because it is carrying
No, absolutely. No, I get you, Justice. Yes, you're right. No, that's a different point. Yes. That point is simply a sub judice point, and I think my learned friend, Mr. Masuku, I'm not going to belabor it, because he's going to deal with it. It simply says that the committee, this committee that is sitting now, actually should not be sitting, because they seem to think that when the rule says you may not reflect on what is in court, it means moving your mouth and talking. No. Reflect, the mere fact that they are sitting when there is a court here, which is to determine whether the proceedings have started and all those things, means that they are reflecting on it. In fact, they did on the first day. All the issues we are debating here had to be debated there, and that's wrong. That's what the rule prohibits. It's just illegal. So, yes, no, but separate point, my learned friend Mr. Masuku will deal with it. I wanted to move to the question of conflict. Sorry, I've got someone starting. Yes. And yes, no, sorry, just to round off this point.
We've got less than 30 minutes left on your time.
Yes, but I have to make this point.
Yeah.
We cannot treat the public protector as if, and that also goes to the points about my learned friend and my learned friend here. We cannot treat the public protector as if she has been removed already. That's the problem. She's suspended. She is the public protector of South Africa. Even the president, both the letter of the 17th of March and the letter of the 9th of June, if you look at them, they say, "Dear public protector." Why? Because she is the public protector. There's no one else who is the public protector. And that point, the point at which all these points can be made, is when she's removed. Then you can say, okay. And Justice Mugu, you made a crucial point in the morning about functions. So there are 3 things which must be distinguished. The acting public protector may assume the functions. But that is, there are functions, there are powers, but more importantly, their rights. She cannot assume the human rights of the public protector or of advocate Mkhwebane. Her rights, which she's asserting in this court, remain hers and hers alone. And the acting public protector has got her own rights, which she can assert. But let's move to the these interlocutory points are really not what the paper they are written on, because the sections, the Rule 7 point is about attorneys, and all that needs to happen is you must show the authority. We have shown it. We'll put it in the papers, and that authority runs through all the cases from the Saldanha case up to now. It's there, as far as the Rule 7 is concerned. As far as the Rule 41 is concerned, it's a non-starter.
I think Mr. President made our work easier. He says there is no Rule 41 before the court. So
okay, yes, because the first words of that rule say a party to the proceedings, so that's the end. Okay. So much for the, and I'm indebted to my learned friends for not opposing the joinder, because Mr. President is quite correct. That point is really just for academic writers, and it is whether you have one applicant or two in front of you. But so what? It really doesn't matter. Now, the point I really wanted to address is the issue of the conflict, which is a central issue. Remember how it is related to the other issue. It is that assume all this, what we've been discussing here, about 194.3a and the interpretation. If I'm correct on that, that's the end of the case. But assume I'm wrong with all that. Then it comes to the person now, the suspender, the actual suspender, advocate, President Cyril Ramaphosa. Now we say, even if a president is entitled to suspend, this president is not, because, one, our courts have said very clearly, my lords, and even the fact that I have to refer to this is just, it shouldn't happen. If you look at the case of the president versus the public protector, that is the 2018 2 SA 100 GP. That's the Mlambo JP court. I'll come to it now. Look, only just in case I run out of time. The president versus public protector, the corruption watch case, the SARFU case, these are all in our hands. Because of time, let me do it like this. I will take, there are 6 investigations, that 4 from Part A you'll remember, and then the 2 that are cited in Part B. But I don't have time now, so I'm going to take 2. I'll only use 2, 1 from each part. In the Part A, I'll use the Busasa CR17 investigation, and then in the ones that came from Part B, I'll use the Pala Farmgate scandal, as it is described by even the president in his affidavit. The Farmgate scandal, let's start with the easier one. Well, they're both easy, but the quicker one, because it has been pleaded previously. My lords, if you believe nothing else from what I'm saying today, it is you have to believe this. The president himself said under oath in the context of the Saldanha J case, he said, I don't think I'm conflicted, but because, and he borrowed these words from section 96(2)(c). That, by the way, I said I'll also give you the installments of why that judgment in Part A is so wrong. You took mine. That's another humdinger. The whole case, we say, the president, no less than the president, says in his answering affidavit in Part A that the only constraint to my power is Section 96(2). He's wrong about that, but let's take it that he's right. He says the constraint to my power is Section 96(2). I accept that. The Erasmus J. Court, you can read it 100 times. Look for the word Section 96(2). Nowhere. They don't address that point at all. So how can that judgment be binding to this court? Remember, there are 3 types of conflicts, my lords. 2 are called, let's call them the common law conflict. And then the third one is the constitutional conflict. That judgment confines itself to the common law conflicts, which are described as follows. It's from Nemo Judex. It's actual conflict or reasonably apprehended conflict. Those are the common law conflicts. That judgment does not do what it should do, which is to address the real point of Section 96(2), which applies not, because the other conflicts, the common law apply to all sorts of people, even if you are just adjudicating dog licenses and so on. But 96(2) only applies to the president. Oh, I'm sorry. It applies to members of the cabinet, which includes the president. So how can you have a judgment on this issue and not address Section 96(2)? It's just, it's not done. Because Section 96(2) lowers the threshold for members of the cabinet, lower than me and my learned friend, Mr. Shabalala. It says very simply that if you're a member of the cabinet, members of the cabinet and deputy ministers may not undertake any other paid work. Let's put that aside. That will come to when we talk about Palapal. B says may not act in any way that is inconsistent with their office or, crucial, expose themselves to any situation involving the risk of a conflict between their official responsibilities and private interests. So that's a lower threshold which is defined by the Constitution by mere virtue of you being a member of the cabinet. And the court in Part A simply ignored it. And that is why in the heads of this matter, the page 1, we give you the preamble again in the hope that if you put it up there, it defines basically what we're talking about. This is what Mkhwebane CJ said in Economic Freedom Fighters versus the National Assembly, otherwise known as the Nkandla case, about how low the threshold is. It's basically on the floor. That's why I keep on doing this, because it says low, it's like, it's no headle at all. It says the potential conflict lies here. On the one hand, the president has the duty to ensure that the state resources are used only for the advancement of state interests. On the other hand, there is a real risk of closing an eye to possible wastage if he is likely to derive personal benefit from the difference on facts of that case. This is the important part. To find oneself on the wrong side of Section 96, all that needs to be proven is a risk. It does not even have to materialize. In other words, the threshold is as low as it can be. Just a risk of a conflict is sufficient. And the court did not address it. What were we saying about that? We were saying, my lords, that once you have CR17 Busasa case, and you have the potential in the unsealing case, so-called unsealing case, to which the president is a party, by the way. He's a party, he's the first respondent. There's a judgment of Sardiwala J here, where it summarizes the arguments of the president in his personal capacity. It's cited as Cyril Ramaphosa. Now, we're saying those proceedings are, if and when the documents are unsealed, have a potential of answering the real question that was in the Busasa question, which is whether the president knew or did not know about the donors. Because that's exactly why they are being sealed, is to hide that information. So once they are unsealed, at least we must at least accept that there is a potential for that to have some embarrass. Otherwise, there would be no purpose in sealing it. So that's the first point. How can anybody say that there is no risk of a potential of the same conflict that he admitted in the Saldanha J case? So it takes the burden from me because he admitted it himself. I don't have to go through chapter and verse. I'm saying it's the same conflict that he admitted under oath. Because his only defense is that no, but the Busasa case itself is finished, which is true. But the point is, the Busasa case is directly intertwined with the other case which is pending. And in any event, the risk doesn't evaporate, as we say, simply because the case has been resolved. But let me make this point quickly. One, if you go to the report, the independent panel report, you will see, I'll give the reference, you will see that one of the charges faced by the public protector in the inquiry down here relates directly to the CR17 Busasa matter. So, so the president, not only is he a potential witness in those proceedings, because they've already called a gentleman who also had complained in court. There's another one who's coming, I just don't want to mention their names, who's coming, who was also a complainant in a court case. So those are all the natural witnesses, because it is only on the basis of those people, the allegations that they made, that the charges, which are based on the court judgment, can be justified. So whichever way you look at it, the CR17 matter features both on the admitted conflict, but B, because it's a charge in the it's like saying somebody, one of the charges is that I stole bread from somebody's shop, but that shop owner, there's no potential conflict. If I meet that shop owner now in church and they are in charge of the committee that axes you, then I have to be able to say to them, no, you can't be in this committee because I stole your bread, allegedly, and was still involved with that issue. It's simple. So that's at the level of Section 96(2), and then the court, the Part A court, makes a cardinal mistake. Cardinal. It says that the president was not given the benefit of the presumption of impartiality.
Double, is it?
And yes, the double reasonable, that's even worse, actually it's triple, because they give him
I'm saying the word, it seems to use the word double something.
Double reasonableness test. Both the double reasonableness test and the presumption of impartiality belong to judges only. They don't belong to a president or any other member of the executive. So that court was completely off the mark, because the president is not a beneficiary.
Does not enjoy a presumption of impartiality.
Absolutely. Yeah. So that's just another criticism. If we can do the criticisms of the Part A judgment, we'll be here all week.
Okay, before you go on to that, just for my own edification, if I understood you correctly, you said that the president admitted under oath,
yes,
to a breach of Section 96(2)(b.
No, I didn't say that.
Okay, perhaps you could just clarify.
Okay. If you go to volume 1 of the Part A, you'll find the quotations, page 26, my lord.
Yes.
Start at 25. In actual fact, the President himself has previously, under oath, in an affidavit filed in Part A of the application that was heard by the Honorable Court, that's the Saldanha J Court, considered and accepted that a potential conflict of interest arises from the pending litigation between himself and me. In that affidavit, he states the following. Section 96(2)(b) of the Constitution enjoins me to avoid a conflict of interest between my official responsibility and private interest. I therefore readily accept that it would not be appropriate for me to exercise any constitutional power conferred on me in circumstances where there is a conflict between the exercise of such power and my private interest. The following paragraph. I am duty-bound to act so as to exclude the possibility of the perception of bias affecting the outcome of any decision that I take in relation to my powers under Section 194(3). That means the suspension powers, okay, of the Constitution. This is necessary in order, here's the key words here. This is necessary in order to, and these words he took directly from 96(2)(b), to protect the integrity and legitimacy of the Constitution and the process followed in relation thereto. Those words come from the President versus RSA Public Protector case, otherwise known as the State of Capture report, where President Zuma was found to be to fall foul of Section 96(2)(b) and prohibited from appointing a judge, not even any other function, a judge who actually enjoys the presumption of impartiality. But the court said no, even though the judge might be, there's nothing wrong, but the integrity of the process must be protected, and you, President Zuma, you cannot appoint the Judge Zondo, as it turned out to be. It was that section that was invoked, and it was that section that we were talking about in the Corruption Watch case as well, and in the three cases that I cited earlier. And then Justice.
No, while you're looking for it, I think I understand your point
Okay.
now.
Okay.
If I can summarize what I think you said, again from my own education, but it's quite an important point to make.
Absolutely.
That the President recognized that there's a potential conflict of interest given his litigation with, or being involved in litigation with the public protector. And he seems to indicate that being the case, he cannot exercise any constitutional power that may have an impact on her, like, for instance, a suspension. Could that be a clear instance of bias?
Yeah.
Is that?
That's what he said. Yeah, that's exactly what he said. And all we are saying, that means the only conceivable way we can let him out of that acceptance is to find some clever way of saying no. In that case, the litigation was still pending. But that's exactly why we answered here, because we say, yes, the unsealing case is still pending. It's common cause. And that unsealing case has got a direct impact. So it's a distinction without a difference to say that this is not the same conflict. You said with your own mouth, I will not be able to exercise the power to suspend when the situation is like this. And we're showing, so the only difference I can have between myself and my learned friend, Ms. Pillay, will be about the facts, whether the situation that he admitted to and the situation we're in now, there's any material difference. Because the admission is under oath, it can't be wished away.
And you say that there's still pending litigation.
Yes, yes, there is, which is directly related. You remember, I don't want to bore you with the facts of the case, but one of the reasons why the public protector was criticized in that case was because it was said by the court in many places that there was no evidence that she had that the president knew about the donors, the CR17 donors, and about his son and all that. Now, that evidence is contained in the sealed document. And so the court didn't say, no, the public protector just woke up and it said, no, she did not have that evidence which could be used. Let me put it that way. Once that is released, then the public protector's jurisdiction will be restored, and so on and so on. So that's pending litigation means it can go either way. We all know that as lawyers. It can go this way or go that way. But the bigger point is that that conflict, then if it disqualified him then, in his own words, with his own mouth, it still disqualifies him now. So, okay, I want to go to Palapala quickly, but I'm told that that reference is at 524, the reference I made earlier about the letter to Mr. Hoffman, page 524, which one? Volume 6 of Part A. Just a quick point, I won't develop it. It says, Dear Mr. Hoffman, dear Advocate Hoffman, your email suggests that the President has discretionary power under Section 104 to suspend the public protector at any time after the start of the proceedings and so on. And then he says, you were correct in raising the possibility of a conflict of interest in your latest email. Because even Advocate Hoffman said, if you are conflicted, you must delegate it to the Deputy President or whoever. And by the way, that's another thing the President said with his own mouth, that I will not exercise the power, I will delegate it to, I think the words he used were, a member of the cabinet
So you say that's page 524, which volume?
524, volume 6 of the...
Which bundle? Huh? Sorry. Bundle A. Okay.
Yes, paragraph 5 of that letter is very important, but I'm just rushing through because
I think you don't have to rush. I think we'll have to give you an extra 30 minutes when you come back, because some of the time was taken up by the
questions.
Not by the questions, by the
earlier
the housekeeping matter.
Yes, thank you.
So we'll extend our time to we'll sit until 1:30.
Thank you.
But when we come back, you must just cut
I'll develop this point, and then very quickly I'll deal with some of the interlocutors. But this is the crucial part. I will deal with the part where the President said himself he would have delegated the matter. I'll start there.
All right. So is this the convenient point where we can...
No, it's not for me. It's not a convenient point. I thought, let me just round off that point then.
Okay.
Thank you, Justice Smith. Because it will make me not to have my lunch in peace. It's burning in my... the President, if you go to the affidavit, Justice Francis, the affidavit that we refer to, where he made these admissions, is quoted in the final affidavit, but it's actually attached to the founding affidavit. And this is what he says. I'm paraphrasing because I can't find the actual judgment now. He says, and if I'm wrong on this, I'll correct myself in reply, but I'm paraphrasing. He says, because of that potential conflict, I will therefore exercise my right to delegate, which you'll find it in Section 90 of the Constitution. Section 90 of the Constitution says whenever the President is unable to act, then he can delegate to the President, to the Deputy President. It's actually exactly the same one that deals with the Deputy Public Protector, word for word. It says when the President is absent from the Republic or otherwise unable to fulfill the duties during a vacancy in the office, an office bearer in the order below acts as President. The Deputy President, Minister designated by the President, Minister designated by other members of the Cabinet, or the Speaker. And he said you would have invoked, as I say, I'm paraphrasing, you would have invoked that. And all we're saying is that that's all he should have done, knowing that there were all these 4 serious investigations, each one of them. All I'm going to say about them, because I don't want to traverse all of them, each one of them constitutes an impeachable offense. It's that serious. Each single one of them constitutes an impeachable offense. No, and unlike the one, when President Zuma had one conflict to do with his son and an investigation into state capture, that was sufficient for our courts to say, you can't touch this. One. against 4. And as if that was not enough, he added another 2. Pala, which is where we will start when we come back from lunch, Justice Nugu, then makes really this point to be so blatant, because it is related to 3 things which I will not discuss, I will just mention now. Why, I'll mention them as rhetorical questions. Why did the President suspend the public protector on the 9th of June, when there was a court case, a judgment coming on the 10th of June about whether he has the power to do so? 2, why did the President, having waited, if Justice Francis is correct, and the power to suspend was triggered on 16th of March 2021, then what was the rush? Because if you waited from 16th of March 2021, and then suddenly on the 9th of June, this is the same person who has given us undertakings, including the possibility, and I won't put it higher than that, of waiting the outcome of Part A. And then all of a sudden, he's forgotten all that. And he has waited for 12, 14, 15 months on the earlier interpretation, if Justice Francis is correct, without doing anything, leaving the person in the office, not protecting the office and the organization and all that. But suddenly, it must be protected before there's a judgment tomorrow. You can't wait one night to get a judgment which you know has been promised by the court is going to come on an urgent basis. Let's assume for a minute that story is true, that the email came at this time or whatever. But he knew that the judgment is imminent. It's going to come anytime. And if it's not tomorrow, it's the next week or whatever. Thirdly, why did it take the public protector writing 31 questions on the 7th of June to do with the Pala scandal for the President to be triggered to act on the 9th prematurely? There is no other explanation unless, again, we have to find, I don't know what, mental gymnastics. The inference is irresistible. There is no other explanation why the President would conduct himself like that apart from retaliation. There isn't. And that, is it consistent with the Constitution? No. Thank you.
Thank you, Mr. Mbofu. The court will adjourn and will reconvene at 2.
I told you Erasmus.
Where am I cited?
What I have. You know what? Now that I've finished, I think I'll also
On the stole it somewhere.
Yeah. Oh, yeah.
Bonke by 3, nala President by 3. Bonke by 3.
It's just a matter of grabbing a glass of water and coming.
Yeah, put that in.
It's this issue about the Constitution says what it says, it says what it says. 194.3a specifically uses the word may, right? What the president may suspend after the start of the proceedings and so on. Contrast that to 194.3b, which says the president must remove a person from office upon the adoption of the assembly of a resolution. For lawyers, what is the implication of that? It means that this idea of protecting the institution cannot be properly used as, let's put it this way, as an excuse or as a reason for using the powers prematurely. Because if that was if the real intention was to protect the institution or the organization, then it would say the president, once the serious allegations have been made, must suspend. After all, he has to protect the public and and all the institutions. The mere fact that the constitutional writers used the word may, it was indicating that they realized that even in the case where there are serious allegations, the president still has to exercise a discretion. Now, that then goes to, and because I don't have time, I'm not going to go through all the, I'll invite the court in your own time, my lords, to look at the letter of representations where we put chapter and verse of why the president's reaction, or rather suspension, would be A, inappropriate, and B, premature, and C, in conflict. And he ignored all of that. And we even showed that this so-called motion of Mazoni MP is so unlikely to pass the two-thirds majority. All those considerations and how long the process is likely to take. A president who actually wanted to protect the organization would not have suspended, because he would have realized that this public protector has been here, these charges have been here for 2 years. The sun did not come from the west. Instead, she actually had 2 clean audits in that period. So there is no crisis, quite frankly. And so he would have realized that none of his actions explain this big rush. The big rush can only be explained by what I'm about to say now. The other point related to this point is this. If you go to page 401, that's volume, I'm assuming it's volume 5. Or anyway, the rules are found everywhere. It's rule 129 AD. This version is on page 401.
So that would be bundle A.
Bundle A, my lord. Yes. There's another giveaway, because a question was posed to me. Well, there's only one committee. But as I say, I'm not being rude, but that's the problem of Parliament. It's not the problem of this court, with the greatest respect, and it's certainly not the problem of the public protector. The committee that was set up says at 129 AD, it's very clear what its mandate is. The committee must, when the Assembly has approved the recommendations of the independent panel, in terms of 129Z, proceed to conduct an inquiry and establish the veracity of the charges and report to the Assembly thereon. Full stop. If Parliament, maybe after this case, once this court or the higher court point out that there is this gap which we debated this morning, then Parliament, of course, is free, for example, to expand the mandate of this committee. let me put it this, it would be wrong legally, but so it might be challenged. So I don't want to set them up for a challenge. So they could say that committee will determine the veracity and then conduct the removal proceedings. That would close that gap. But if the gap is there, it's not our problem, so to speak. But for now, the mandate of the committee is confined to establishing the veracity and report to the Assembly. So that's just the points that I wanted to clean up on the...
So, Bobo, while you're in the cleaning up
Sorry.
process, if you have a removal committee, what is the purpose of the National Assembly then?
Well, the short answer is I don't know. But the long answer is this. There is nothing, it's conceivable, Justice Francis, that the founders of the Constitution, let's assume, just work with me for a minute, assume that they conceived such a thing as a removal committee, okay? Now, they might have had the situation that we were talking about earlier in relation to the JSC. Because actually, in the example I was giving you of judges, the JSC, the small JSC, is, once the finding is made, becomes a removal committee. Because by then it's seized with only, once there's a finding that says there's gross misconduct on the part of a judge, then the JSC, for all intents and purposes, sits as a removal committee. Because and it happens, it takes a long time. You know, it might look on paper that, oh, well, it's just, you know, to press a button and send a fax or whatever. No. The JSC can be seized, as would such a committee be, with this matter. It can be very complicated, and I'm talking from personal experience. It can be very complicated as to, for example, whether you make the recommendation for a suspension. Remember the JSC, when it sits at that point, one of the functions it must make, I think it's 177.3. Yes, it's 177.3. Yes, the President, on the advice of the Judicial Service Commission, may suspend a judge who is the subject of a procedure in terms of subsection 1. What that means is when the JSC sits in the manner that I've described, then the President may suspend in the same way as 194.3a. So the short answer is that committee would perform the exact function that is performed by the so-called small JSC, which is to process the motion, send it to the speaker, whatever. It should have been defined in the rules. But if it wasn't, it wasn't. That's their problem. So they could have said, for example, this same committee will also sit as a removal committee. But on the rules as they sit now, and on the Constitution as it sits now, it is not. And with the greatest respect, the question is, really, it's a conceptual problem. Because you have to look at it this way. You have to almost assume that there were rules, and then there was a committee, and then the Constitution was written, knowing that there is a committee. But it's actually the other way around. 23 years later, the rules were written. So if the rules don't speak to the Constitution, that's a problem that the court cannot resolve. Because if the Constitution conceived of such a thing, let's say the Constitution conceived of an appeal from this committee that's sitting now, and it says you can suspend after the appeal, but the rules don't have an appeal committee. The court can't cure that by saying, oh, well, we'll just use this one that we have, this committee, when they failed to actually constitute an appeals committee, and I'm using that example just for emphasis. But the crucial point is that the word may is a giveaway that even if all the conditions were met, the President doesn't have to, there's nothing compelling him to suspend. Nothing.
And just on that, I just want to be sure that I understand your argument correctly. In other words, if your alternative argument were to be accepted, the constitutional power for the president to suspend, if I understand correctly, in this case will have only been triggered after there was a formal commencement of the proceedings.
Absolutely.
In this case will have been the 11th. Do you understand correctly?
The 11th, yes. On the alternative, that's correct, Justice Lukuli. On the alternative arrangement, argument, assuming I'm wrong on everything else, the commencement would have been on the 11th. But the giveaway is that then both the triggering of the 17th of March and the 9th of June fall before the 11th. So still, the suspension would be unlawful.
Yes, on the interpretation, at the interpretation level, the commencement of the proceedings, or the start of the proceedings, do you understand correctly, it will mean the formal commencement of the proceedings, not necessarily the referral of the matter to the committee.
Absolutely. What we call, remember in Part A, we call them administrative, like those meetings where they meet and say, let's do scheduling and so on. Those cannot, the constitutional writer's role really could not have thought, well, if you just meet and say, okay, are we going to meet in room 25 or in room 26? They call that's a point at which such a big constitutional matter must happen. It must mean something which has juridical value, which happens where the guillotine falls somewhere. And firstly, it must be known and knowable, not this fuzzy stuff that we're getting. But secondly, it must be, it's like saying, in fact, I wanted to make this example to Justice Nuku before tea. When you were saying, well, they're saying no, maybe, it's like saying you can only vote when you are 18. There's a date. You can't say, no, well, if you look a bit 18, and it must be on a knowable date that on your 18th birthday, now you can vote. Everyone knows it. It's on, in my case, 26th of September. You turn 18. That's it. It can't be, no, well, what about, let's look at the values and maybe, no. So, right. So let's then come back, because this links to the point that I was making. Justices, I'm back with the conflict point. This is, let me just do this for 2 minutes, just to paint the real picture of what we're dealing with here, which is a gross abuse. So you have the agreement. Let's talk about the agreement. Agreement between council, which we invoke. That agreement is not, there's no debate about it. Any debate about that agreement is just contrived. Paragraph 3 of the agreement is very clear. It says, the president will receive your, I don't want to speak as if I'm a witness. Let me just speak on the basis of the affidavits. There's a debate. You have to look at, to see why this thing is being fudged. Every time the president deals with that agreement, he doesn't deal with the letters that are before the 30th of March. Nowhere. And you know why? Because in the letter of 30th of March, or rather of 25th of March, he said, I will not suspend until the outcome of Part A, provided the matter is heard on the 26th of April. Simple. No complexity there. The DA wrote him a letter, big complaining letter, saying, how dare you do this? You should suspend, you should have suspended yesterday, and so on and so on. How can you allow this, and so on? The president wrote back to the DA and said, I know my obligations. Thank you very much. Basically, it was like a very curt letter. That just said, like, stay in your lane. Okay? Then, because of the Abraham G story, the matter then gets moved. So the 26th of April, which was supposed to be the start of these proceedings here, is moved to the 18th of May, okay, for issues that don't concern us now. So all we were saying, we then say to them, let's restore that agreement so that you can only suspend, if you have to, after the outcome. So that's why that agreement, the SMS, the WhatsApp, is on the 20th of May, because it's the day after we were here. I stood in this very spot and I said to Justice Erasmus, because I was rushing for an aeroplane, so I said, my lords, because we don't have a lot of time, I was going to address you about making an interim arrangement, a holding arrangement, because the justice said, we know this thing is urgent, we might even just give you an order next week, and so on and so on. So I said, I was going to address you to make an arrangement. And I said, you see in that transcript, I said, but myself and my learned friend, Ms. Pillay, have been working well together. I'm sure that I don't have to address this now. We will have some arrangement outside. And the matter was left on that basis. That's the 19th. I moved from here, took an aeroplane, gone to Joburg. 8 o'clock, you'll see that message, 8:05, to council to say, let's have that arrangement about holding until the outcome of the, and then it comes back with a counter, which is what is in there. And it's conservative, but it's understandable. They say a very simple thing. No, give us the representations. The president will then consider whether to make any undertaking. And he will come to you and advise you if he's making such an undertaking. If so, he will tell you the terms thereof. So I talked to the client, she's happy, no problem. Because this is clear, the reason we want that window is so that if there's a threat of a suspension, we can go to court if we have to or whatever. That's all. We just want to know whether he's going to suspend or he's not going to suspend, or whether he's going to give us undertaking. No. Boom. On the 9th of June, suspension. No notification. Nobody has said, no, that undertaking is, we're not going to give it to you for this or that reason, or we're going to give it to you. No. Why? Because there's a rush about Palapala. That's why. So so that's the first thing. The second one is the one I said before lunch, my lords. With all that background, at some stage, and I admit that the undertaking kept on changing shape and getting more and more conservative. I'm not there. But one thing that is sure is that at some stage, somewhere in March, they were prepared, and that's why the DA had to scold them, to give an undertaking until the outcome. They knew the importance of that word, until the outcome of the proceedings. In fact, for all the criticism that I've given to the Part A judgment, there's one paragraph that is good there, at least. It says at paragraph 14, praising the president. Again, as accommodation, the third respondent, that's the president, agreed to delay his decision. You'll find that on 250. Agreed to delay his decision on whether to suspend Advocate Mkhwebane, so that she would be presented with an opportunity to challenge his right to do so. It can't be clearer than that. If she was going to be given an opportunity to challenge his right to do so, and also the right to proceed with the impeachment inquiry, then surely it says what it means and it means what it says. But the point is this: who in this country has a right to give the middle finger? I can't put it any more polite than that, to the courts, and say, I know there's going to be a judgment, I know there's a challenge, I was a party to those proceedings, but you know what, I don't care what the court is going to say. I'm just going to do, if we can allow that in the name of whatever, I don't know, that any party must say, if the president, no less than the president, can say, the court is seized with this matter, I know it's coming, and I say again, let's grant him, let's say he didn't know that it's coming tomorrow. Let's say he just knew that it's coming urgently. I know that it's coming soon, but I don't care what the court says, I'm suspending. As lame as they came. Who does that? Who does that? You know? And if we allow that in this country, for anybody, then we're on the road to nowhere. Now, the president doesn't stop there. He breaks his own agreement. He breaches Section 165 of the Constitution, which says the courts must be respected. He acts precipitately a day before. But one doesn't have to be a lawyer or a genius to know why. Surely, but surely, this must have something to do with the questions he received from the public protector about the Pala Gate scandal. There's no other intervening, nothing. There's nothing else that happened for him to do all these activities, except that he received questions which were uncomfortable about possible criminal activities on his part and activities that might result in his impeachment. And then he comes here and tells us this application that is being brought now to say, oh, well, he says firstly in the papers, I don't know what the fuss is about. I have fully cooperated with every investigation. Where? Firstly, he's given to respond. He says, no, he's exceptionally busy. Exceptionally busy. In that period where he's exceptionally busy, he hosts an Ankole sale auction on the 18th. This is remember he got the letter on the 8th. More than 20 days later, in the period of exceptional business, where he can't attend to 31 questions about something that happened 2 years ago, he does that. And then he's given not the 7-day statutory period, he's given another almost a month, just less than a month. He doesn't meet that deadline. Again, exceptionally busy. Until he's threatened with a subpoena. And then he complies with the subpoena on Friday, which means if on Monday last week he couldn't comply, but he was able to do it within 3 days once the subpoena came out, then it means he could have done it on the 11th of June. But that's not enough. Then he says, no, I'm not going to give you the answers. You, the court, and us.
But he doesn't say so, Mr. Mkhwebane. He says that he's prepared to, he'll abide what the court says, but he just wants to bring it to the attention of the court that it has been conveyed to his legal representatives that the answers should only be provided to the office of the public protector.
Yes. No, that's what he says. I know. That's why we did the counter application. But a person can say anything they want, Justice Smith. We have to scrutinize the facts. Context is everything. What is the real problem? Nobody.
But there's an email there which is the real thing that he wants to
invokes.
Yes.
No, fair enough. But the point I'm making, Justice Noku, is that if someone is really so willing, in the name of transparency and all these good things, to assist, then they say, we will make an arrangement for, and I'm just thinking off the top of my head, we say this in our application, we'll make an arrangement that the answers will be seen either by the legal representatives or by the clients or whatever in chambers, something like that. Why? Because it's relevant to his claim under oath that he has fully complied. How do we know that that is true? What if those answers are just the letters of the alphabet?
But that's not for this court to deal with.
Well, he said it in this
All
court.
that this court must do is to scrutinize whether his conduct accords with what the Constitution requires of him.
No, if that was so, then he would never have told this court in his affidavit 3 times that he has fully complied. If it had nothing to do with this court, he would have told anyone else who cares.
No, all I'm saying is that we don't have to follow every little piece of allegation. It must be relevant to the issue that the court is seized with. Here the applicant comes to court and says to the court that the conduct by the state actors in the person of the Speaker, the President, and the Chairperson of the committee is unconstitutional, is invalid, is unlawful because of ABC.
Okay, I'll leave it. Yeah, no, that's fine, Justice Smith. Let me just leave you with this rhetorical question to ponder on. If what you're saying is correct, if the answers have nothing to do with this case, then why in this affidavit does the President say, I wanted to give it to this court? For what? Because it's irrelevant. So if the mere fact that he says, if it wasn't for the acting public protector basically gagging me, I would have given it to this court. For what? It's because he knows that he would have given it to this court because it is relevant. Otherwise, this court is not here just to get pieces of paper that don't mean anything. He knows, Justice Nuku. That's why he did an affidavit on Saturday and said to this court, you'll forgive me, I'm not going to give you the answers. But that's fine. Let's say that it's...
the time is
he was, yeah. Yeah, well...
That's why I'm trying to move you so that you don't miss the important issues that.
Well,
because you must still tell us you must still address us on the development of the common law.
Yes.
What is the other issue?
Section 7, Rule 7.
Rule 7.
Section 7.
So you'll really have to just now focus.
Anyway, look, the point is quite simple. If there is no other explanation except for the conflict for breaking the agreement, for breaching Section 165, for being in contempt, and really at some point we must not underestimate the intelligence of the public, because the public knows that the person got answers, questions on such and such a day. 24 hours later, they suspended the person, and a few days later, they were stuck without being able to give answers. So unless if there's another explanation, maybe it will be given, then it is clear that the Pala Pala Farmgate issue is a source of a disqualifying conflict of interest on the part of the President himself. There's no two ways about it. It's the biggest problem that he's facing. And it is the author of the 31 questions cannot be expected to be subjected to the neutral decisions of the person that they were investigating. Then the other reference I want to make is that page 1079, that will be volume 11 of Part A. I won't develop this. It's just the cover page of the unsealing of the CR17 cases. You'll see that it says Economic Freedom Fighters versus Matamela Cyril Ramaphosa, first respondent, and then 1079. And then the president somewhere makes it look like he's just a peripheral party. But at 1084, you'll see the judge actually summarizes the first respondent's argument. First respondents admitted the CR17 campaign has ceased to exist, and so on and so on. It was a private political matter, and this is the problem when you try to escape and something that's inescapable. Remember, in section 96.2 says the president says, but these are all my official duties. There's no private matter. But here in this case, he says it was a private political matter. So, bringing himself directly into the clutches of section 96.2. The common law issue, again, is simple. I'll do it like this in shorthand, Justice Luke. We are saying, we accept that the law as it stands, especially since the introduction of the Superior Courts Act, and read with Rule 45A, is that when you, unlike in the case of an appeal, when you appeal, automatically the judgment is suspended, right? And it doesn't matter, and again we tried to explain this to the previous court, it doesn't matter if your appeal is good or bad or indifferent.
It's a default position.
That's it. It's the default position. The mere invocation, because that court will say, no, but you'll see, they say it has 0 to 0 or whatever. No, it doesn't matter what the merits of the thing is. Because it goes back to this issue of protection, Justice Francis. That is not just something that's put there for fun. It is to protect the person's Section 34 rights. To say, you're right, what would be the point of appealing, and then you win 2 years later, but the car, as we're talking about, is gone. So it's to protect the right of the individual, once again. Now we're saying a very simple matter. We're saying that rule, insofar as it is grounded in Section 34 of the Constitution, should be extended to rescissions. Because logically it's the same thing. If I'm saying I'm rescinding a judgment, it means I have a potential to win or to reverse it, to set it aside, in the same way as I have a potential to set it aside on appeal. So what's the difference? But here's the shortcut. What we're asking for is the return. I'm sure all of us in here are old enough to remember Rule 49.11. That was repealed by the introduction of the of Section 17 of the Superior Courts Act. Anyway, I'll paraphrase it. Rule 49.11 said the following: whenever you put an application for leave to appeal or an application for rescission, the judgment is suspended. That's what the rule said. We all grew up under Rule 49.11. And if you want a shortcut, what we are saying is that because the framers of that rule knew what I'm saying, that there is no philosophical or jurisprudential difference between a person awaiting a judgment on appeal or someone awaiting a judgment on rescission. So if you want to cut all what I would have said if I had time, that relief is asking for a return to Rule 49.11.
But the argument against that seems to be that you now have Rule 45 capital A,
yes,
which provide explicitly to the opposite. And there is no frontal challenge to Rule 45A. So you have that headway.
No, that's okay. That's just.
I'm just putting it to you so that.
No. Fair enough. It's put there. I'm just saying that's just pushing technicalities to the limit, because that argument actually goes even further. It says that we should have also attacked
Section
18. No. If it's just as I say, Justice Nuk. By the mere promulgation of Section 18, for example, that basically killed, quote unquote, Rule 49.11, because now the bar was lifted to only appeals and rescissions were relegated. All we are saying is that if the adjustment of the common law as we propose is accepted, then Parliament will do what it has to do. The rule makers will do what they have to do. That's how these things happen. You don't.
But that's like directing them to legislate in circumstances where there is no defect that has been pointed out in the legislation in the form of a frontal attack of that legislation. Okay. I think that's the gist of the
defense. Yes. Yes. Well, yes, I understand that, Justice Smith. The point I'm making is that the attack that we have mounted on the, remember, all these things emanate from the common law, but the common law itself must be interpreted in terms of Section 39(2) of the Constitution progressively. I'm just using shorthand. It must be interpreted for a country which respects human dignity and so on. That's the fundamental issue. Does the rule as it stands, which it's almost like if these were people, you'd call it an equality clause. Does a rule that discriminates, quote unquote, between an appeal and the rescission meet constitutional muster when the fundamental issue is the same? Remember, what we're saying is that we develop the common law. That's what we're saying. We're not saying attack what the rule this or rule that or rule that. We're saying you must develop the common law to accommodate this unfair discrimination, quote unquote, between the two things that should be treated similarly. Once that common law is developed, we didn't come here to say strike out this or that. It follows that once a court of law says that this discrimination between these two sections is unconstitutional, offends Section 34 of the Constitution, then everyone, all of us will have to do what they do. What is it called? The Rules Committee will do what it has to do. The Parliament will have to do what it has to do. The job of this court is simple and must not be complicated. It is not to draft some rule. It is to develop the common law, as it is enjoined to do in Section 39(2) when it does an interpretation, and as it is permitted to do in terms of 173 of the Constitution. That's it.
Does that not offend against the finality of judgment? Does that not erode the finality of judgment?
Thank you, Justice Lukuleni. Yes, the question is no, it doesn't. Because if it did, then to cure that defect, Justice Lukuleni, we must then abolish the thing called rescission. Then we say, because we say, to protect the finality of judgments, once the court pronounces, that's it, right or wrong, especially if it's the apex court. You can say you can appeal and appeal, but at a particular point, that's it. If that's what the mischief wanted to cure. But no, the answer, therefore, to your question is no, it doesn't. Because if it offends the finality of judgment, then similarly, it must offend in terms of appeals. Yeah. And it's a simple issue of saying, as I say, let's return to the position that we all grew under of equating, to be honest. Rule 4911 equated the rescission and appeal in respect of the automatic suspension of the underlying judgment. That's it, nothing more, nothing less. And we do that because that is affecting us, basically, directly, in this case. Because if what was pending now in the Constitutional Court was an appeal, nobody sitting here would quibble about the fact that they can't do what they are doing in Parliament and all sorts of places. They would know. But simply because it's a rescission this time and not an appeal, they feel that they are free to do what and they are, because the common law has been wrongly, or rather has not been developed fully to accord with this book, which is Section 34 of the Constitution. That's why they are able. There would be, if there's an appeal, there would be no inquiry going on now. There would be, all this debate would not even take place. In fact, after all, that is what the Deputy Speaker, Mr. Tsinodi, did. As soon as there was an appeal, he, of his own volition, without us having to bring a Section 18 application.
You need to wrap up, Mr. Mkhwebane. You've made that point, I think.
Yes. Mr. Tsinodi, without us making a Section 18 application, voluntarily suspended the proceedings. Now let me move to quickly, if there's any need, to the Rule 7. The Rule 7 is a non-starter because it seeks to attack the right of Sianeho attorneys. Remember, the thing about withdrawing the application is gone. So we just talk about whether the attorneys are empowered, which is what
Maybe we should address it in reply, because I don't quite understand it, because there seems to be no question about them having been instructed initially, and then now all of a sudden in the middle of litigation, what has happened?
Yeah.
You know?
Nothing.
So perhaps Mr. Breitenbach will enlighten
Yes.
us, and then
I'll deal with it in reply. Safe to say this, my lord. In Erasmus, it's
and it
explained.
seems to be nothing more than to, for lack of a better word, because when she was suspended, it was on terms that she would retain all benefits.
Absolutely.
And this must be one of those benefits.
Of course.
And now to want to
strip her.
Yeah.
No, it's the indignity of it all. All these actions is to try and
especially
humiliate.
coming from state actors is a bit, perhaps they will explain it.
Yeah, maybe they'll explain better. But it's part of the campaign to humiliate and make sure that she is put out there to hang and to look like a person who is abusing state resources, because these documents are in their possession. And to invent this thing called PPSA, or the Office of the Public Protector, or to latch onto the judgment, which is clearly wrong, at paragraph 77, which says the applicant here is the Office of the Public Protector. And then my learned friend says, yeah, look, if judges say that stare decisis,
Is there any other point you want to make?
If the court can just literally give me 1 minute, just to make sure that I'm not leaving out anything that's crucial, so that in fairness, my learned friends can. In the WhatsApp, I will address the court. I just want to attract the court to paragraph 3 of the WhatsApp. I won't develop the point now. Urgency looks like it's not going to be an issue, but the abuse of court point is going to be pursued again by state actors. Thank you, my lords. If there's anything that I violently want to introduce, it will be obviously subject to my learned friend's right of reply. But those are our submissions, my lords, and I just want to round it off by ending where we started. This case is about one thing only. The conduct of the president, in particular, in abdicating his powers, passing the buck to the speaker, acting in the way that we have catalogued in respect of the interpretation point only. Is it consistent with the Constitution? And is that, objectively speaking now, is that interpretation correct? Yes or no? Is the committee a removal committee, and has the time come? If it did, when did it come? Put that aside. Assume we are wrong. Then President Ramaphosa, faced with 6 investigations, all of which relate to impeachable offenses, including the one that is brewing up now. Can he, by any stretch of the imagination, be permitted, in the face of Section 96(2) of the Constitution, which says you must, even the risk of a conflict, you must avoid? Can he be the person? The answer again is a big no. That's the court visit.
Thank you, Mr. Mbofu. Mr. Masuku indicated that Mr. Smelane will address the court. You may proceed, Mr. Smelane. Sorry, Mr. Simelane, it appears that you have to be close to a mic because otherwise we risk not recording you.
I could have used those minutes.
My Lords, the heads have been submitted with your indulgence, for which we are absolutely grateful. I won't dwell much on them because of the limited time. I will, however, wish to start with the preamble of our Constitution, which is what this case is about, after all, the Constitution. It says, "We, the people of South Africa, recognize the injustices of our past, honor those who suffered for justice and freedom in our land, respect those who have worked to build and develop our country, and believe that South Africa belongs to all who live in it, united in our diversity. We therefore, through our freely elected representatives, adopt this Constitution as the supreme law of the Republic, so as to heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental human rights, lay the foundations for a democratic and open society in which government is based on the will of the people and every citizen is equally protected by the law, improve the quality of life of all citizens and free the potential of each person, and build a united and democratic South Africa able to take its rightful place as a sovereign state in the family of nations. May God protect our people. Kosisigele Africa, Murena Bulugas Chavasayesu, God Sien South Africa, God bless South Africa, Mudzimu Fatucheza Africa, Kosi Katekisa Africa. That is very important to reflect on. In fact, the Constitution goes in section 2, it says, this Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. Now, where am I getting with all of that? This case is here by the applicant purely because the National Assembly started a process, and as a result of which the Speaker of the National Assembly wrote a letter to the President which triggered a particular course of action. Now, in the triggering of that particular course of action, what we do know, and is not contested by any of our learned friends here, is that there is the sub-judice rule that becomes applicable. Why? For the simple reason that there is currently pending proceedings in a court somewhere, the outcomes of which have the potential and may very well affect this particular case. So we're dealing with the simple application of the sub-judice rule. Our learned friends in their papers have argued extensively on their interpretation of the impact of those particular proceedings in the Constitutional Court to these proceedings here. We're going to give you our assessment of what that impact may very well be. But the fact of the matter is that there is proceedings there. Then you have Rule 89 of the National Assembly. Rule 89 of the National Assembly is very simple. It basically says, no member may reflect on the merits of any matter on which a judicial decision of a court is pending. May reflect on any matter. Literal meaning, literal interpretation, straightforward, no mess, no fuss. You may not reflect on what does that mean constitutionally. What it means is exactly what it means, which is that the members of the National Assembly may not interfere with court proceedings in another court, simply because by reflecting on any matter on which a judicial decision of a court is pending, they are impinging on that particular matter. For the simple reason, because as the proceedings sit in the National Assembly, they are aired live on TV. Everybody can have a look at them, including judicial officers. Anybody who is a participant in those court proceedings is having a look at those proceedings and is able to use those proceedings to formulate an opinion about what their attitude should be in those particular court proceedings, and thus affect those court proceedings. In Part A of this application, we even had an unfortunate circumstance where potentially an outcome of the court impacting on a hearing in that particular matter came before the matter could even be heard. Clear impacts could be seen. Clearly what Rule 89 intended to avoid took place under those circumstances. So Rule 89 as it is, preventing the National Assembly from commenting is important. Why is it important? Why is it important? Is it important because this again is about the Constitution. The members of the National Assembly, firstly the Speaker. In her capacity as a Speaker, she acts on behalf of the National Assembly. The National Assembly members, the members of the National Assembly take an oath of office. They are put there to reflect the will of the people. That's why they are elected representatives. And what they are assigned and tasked to do is to protect the values in this Constitution. In this Constitution. They cannot act in any manner themselves in their representative capacity and also individually as members of Parliament because they take that particular oath. Their duty is to protect this Constitution and ensure that its values are adhered to. So the lawfulness of any process, firstly by any member of the National Assembly and by the National Assembly itself, does matter for constitutional purposes that I have indicated, if you follow that particular scheme of things. So what does then the sub judice rule relate to? It relates simply to a separation of powers. It seeks to protect a separation of powers. While we are busy as a judicial branch of government in particular matters, no other branch of government must interfere with our work, and vice versa. That is what it sought to do. So by therefore triggering the action that the Speaker triggered, commenting those processes and informing the President accordingly, well, the President is entitled to think what he thinks of that.
Is this aspect that they are reflecting on the merits of which matter and what are those merits, because on the papers it's kind of glossed over. So I thought I should ask you to help us.
Well, absolutely there are. Well, Section 181 matters because, again, in triggering the President's action, the President equally has certain obligations, not only as head of state, but as just a normal citizen of the country. He's got obligations which you must follow, because in 181, what it tells you, and the importance of that chapter, is what those institutions, including the public protector, were set up to do in terms of the Constitution. Those are institutions that support constitutional democracy. So they
Let me just make this one example that comes to mind in relation to this matter, which to me clarifies this issue of that rule. There was a stage when the proceedings for these proceedings could have gone ahead, and the applicant pointed to the fact that there is pending litigation. You can't deal with this matter because this matter is still before the courts. And it seems as if that was good enough to stall the process. So that litigation was finalized, and so the Parliament could then process the matter. Now, that's on the facts there, you have a matter which forms part of the complaint, which is going to be subject of a Section 194 committee. So by dealing with that matter, you'll certainly be reflecting on the matter that is pending before the courts. I want you to give me facts in this matter that demonstrate something of a similar nature.
Well, I think the rescission application by the public protector is basically the matter that is pending before the court, which, if she succeeds on it, will impact on this particular court and everything else that is proceeding in this in this particular court. So for that reason, Section 89 as a constitutional matter and separation of powers matter does come to bear.
But the rescission is not concerned with the merits of the inquiry. I think that's the counter-argument, which I invite you to address.
No, it does count to it, because the basis on which the proceedings in Parliament have started, it's on the basis of incompetence, it's on the basis of investigations by the public protector, the outcome of which ended up in the courts, and the courts ruled against the public protector. And based on that, it is argued that the public protector is incompetent, right?
Let me put this to you. The merits of what is before the court is whether that judgment is rescindable in respect of that aspect which relates to the appointment of a judge to that committee. Now, that's not the issue that the Section 194 committee is dealing with, in my view, or you can persuade us that it is. Because I think that seems to be the nub of the matter.
Well, I think the issue of the panel is being attacked on the basis of its lawfulness. That maybe the panel, in the manner in which it is set up, and the manner in which it was set up then, and how it then proceeded with its work, is tainted by the unlawfulness of the presence of the judge. So to the extent that if the court finds in favor of the applicant, it may have a consequential impact in the rest of the work that the committee does. So that would then affect the work of the committee going forward. So in that respect, I submit this court should not then allow the committee to proceed under the circumstances that it is currently under. So if there is then no conflict about what the sub judice rule applies to in relation to the Constitution, my lords, and that secondly the actions of the President in response to the letter that is given is bound by Section 181 of the Constitution and his other powers to observe, uphold, and protect the Constitution, would submit that this court should not accept the invitation to allow the other two branches of government to escape their constitutional obligations to protect the Constitution, whatever the consequences are, because the remedy that they have is simpler than may have been presented here, and that is if the work of the committee is held in abeyance for a while, there is enough time for the court to conclude its court proceedings, making Section 189 no longer applicable. And in response to the question Justice Francis asked, what should the President have done on receipt of the letter? He should have taken proper advice. He should have considered the impact of his response to the...
I must leave that to Mr. Mpofu, because my reading of the papers was that the simple issue that concerned the 10th and 11th respondent was that they may be participating in a process which is not good in law. Yes.
No, absolutely. In closing, my lords, all I would say is that by proceeding with what the committee is doing, proceeding with its work, it is reflecting on a matter that is pending before the court. And without a qualifier to Rule 89, this court cannot read a qualifier in Rule 89. And all that is left for the National Assembly is rather use its own powers to correct its own rules to give it the intention that they wish to have. Currently, it doesn't exist. And this court, we submit, should maintain and protect the Constitution and the separation of powers in particular.
But does that rule, does the application of Rule 89 still finds application also in this proceeding, this proceeding?
Yes, it does, because these are interconnected cases. They have an impact on each other. The consequential action that Justice Nugu spoke about earlier also applies here. This is the Part B of the whole application. So they do have an impact on each other.
Yes. If I understood your argument correctly, the problem with the impeachment continuing, is that another court is seized with a matter which has a material or may have a material impact on the continued functioning of this committee. And that's in relation to the composition of the panel. And that panel, in a sense, and its findings, that it was a prima facie case, that triggered the 194 committee ultimately. Is that so?
Yes.
Now, if I understand the position correctly, that 194 committee, and this is assumed that it's a proper committee for the time being, for the sake of argument, that committee is not bound by the panel's decision at all.
Yes.
It's going to make a fresh determination, or the only link between the panel and the 194 committee is that the panel triggered the need for a 194 committee. So when the Constitutional Court is deciding the matter and making its decision, it's not really making a determination on the merits of the matter before the 194 committee. It might well make a finding on the process.
Yes.
In which the 194 committee, that ultimately led to the 194 committee being established.
Yes.
But it's not dealing with the merits.
Well, the fruits of the poison tree, isn't it? Because what then is going to happen is that the 194 committee is reflecting on the work that was done by the panel. All talk to each other. So if, for example, in the panel, there is a violation of a constitution or any right in the constitution rendering that particular violation invalid, and it impacts on the rest of the proceedings, anything may happen. It may turn to the whole proceedings, it may turn only a certain part of the proceedings. So what we submit, my Lord, is that we can't pick and choose about to which aspect we wish the Constitution to apply and to which aspect we wish the separation of powers doctrine to be applied to. We submit that this court should leave it to the other two branches of government to do their work, get their houses in order, without a third branch of government interfering with it, for reasons that historically we've known around what lack of holding each other accountable, especially by the National Assembly, of the executive can result in. And therefore, in this case, we submit that this court should actually take a firm stance where there is a possibility that something like that may happen. The rest of the concerns that have been raised by the other parties, around what the applicant may be seeking to avoid with respect is something that will still take place down the line. Accountability will always happen down the line. There is no reason to be concerned about that. We should be more concerned about what this court as a judicial branch, as a third branch of government, is being asked to do in relation to the applicability of the separation of powers via the Rule 89. Please. My Lord, I just confirm my name is Senior, and the point that I would then wish to make is that the merit of this part of the case, the Part B, are before the Constitutional Court, and up before this court, and therefore, on that reason, they are impacted upon by what Rule 89, Rule 89 actually does say. Yeah.
Is that all, Mr. Smelana?
Yeah, that's all with respect to the merits I wish to submissions I wish to make, my Lord. With respect to tomorrow, we beg leave to be excused, my Lord. We are in another court on a matter we unfortunately cannot get out of. Circumstances beyond our control. and we yield our time to Mr. Mkhwebane as a court case.
All right. You are then excused in respect of tomorrow's proceedings. Thank you, Mr. Smilani. Mr. Breitenberg.
Thank you, my Lord. Mindful of the limited time that I have and the number of issues that I have attended, I have prepared a transcript of the case that I intend making today. I have copies in the court. I would be happy to hand out copies to the court and to distribute them amongst my colleagues to ensure the alleviate the burden of notice. Also, those are not today, those are the bundles of authorities for the respondents.
I was going to say that they look rather
intimidating.
My Lord, sorry, I haven't got the chance to speak to those. We ask you to hand up consolidated bundles of authorities for the respondents. Those are what we have.
These are what they have been emailed as well, as I understand. Yes. Thank you.
May I distribute my notes?
Yes, you may distribute.
Thank you very much.
The note is not that thin either, but it's better than the bundle.
Yes, thank you, my Lord. It's
you
in
may
14,
proceed, Mr.
Thank you. It's in 14 points side so that I can read it easily. We shall present the oral argument for the Speaker and the Chairperson of the Section 194 Committee, Mr. Dyanchi, in line with the structure of our argument. First, we shall deal with their application in terms of Uniform Rule 7.1, challenging Cianago Inc.'s authority to represent the Public Protector in the period since the President suspended Advocate Mkhwebane from office on the 9th of June 22, and specifically the notice in terms of Uniform Rule 28, which Cianago Incorporated delivered on the 17th of June. The second issue, or perhaps I should then immediately say, we will not be dealing with Advocate Mkhwebane's contingent application for admission as the second applicant in the present matter. The contingency being the upholding of the challenge to Cianago Inc.'s authority. The reason is that, as explained earlier, the Speaker and Mr. Dyanchi do not oppose that application. The second issue that we shall be dealing with is our point in limine that the current urgent application for Part B relief, and I stress against the parliamentary respondents, constitutes an abuse of the process of this court. Thirdly, and in the alternative to that preliminary point, we address the merits of Advocate Mkhwebane's case against or concerning the Speaker, the National Assembly, and the Section 194 Committee, and there are 6 merits issues. The first merits issue is the constitutionality of the Speaker's letter to the President of the 10th of March 2022, informing him that on 22 February 2022, the Section 194 Committee had met, considered the CC's judgment of 4 February 22 and decided to resume its consideration of the motion for the removal of Advocate Mkhwebane from the Office of Public Protector. The second merits issue is the one on which you've just heard argument, namely whether the Section 194 Committee's inquiry will infringe the sub judice rule. Thirdly, whether the Section 194 Committee's inquiry is impermissible because the National Assembly has not amended the new rules to give effect to the Constitutional Court's 4 February 22 order declaring the proviso to Rule 129A(3) unconstitutional and invalid. The fourth merits issue concerns Advocate Mkhwebane's allegations that Mr. Dyanchi refused her an extension of time to respond in writing to the charges against her before the hearing of evidence by the committee started. Fifthly, whether the Section 194 Committee's inquiry will be impermissible due to the second Constitutional Court rescission application if this court were to grant Advocate Mkhwebane's prayer for the development of the common law to include a rule automatically suspending the execution of an order which is the subject of a pending rescission application. The sixth merits issue is then whether the common law should be so developed. Lastly, we deal with the question of costs. If Advocate Mkhwebane succeeds, or loses the present application. We shall not outline the key events insofar as they relate to the relief sought against the Speaker, the National Assembly or the Committee. As the Court knows, they are set out in the chronology table which accompanied our heads of argument. From time to time, we shall be referring to the rules of the National Assembly governing the Section 194 process, a copy of which is in the Part A record. It's Annexure NMN3, Volume 7, page 687. And we shall also be referring to Ms. Mazzoni MP's motion calling for Advocate Mkhwebane's removal from office, a copy of which is also in the Part A record, NMN4, Volume 7, pages 689 to 699. That then brings me to the first issue, which is the Rule 7 application. As the Court knows, my clients have invoked Uniform Writ Rule 7.1. They dispute the authority of Cianago Incorporated to continue representing the Public Protector in the period since the President suspended Advocate Mkhwebane from office on the 9th of June. And they specifically dispute his authority to deliver the notice in terms of Uniform Rule 28 and the amended notice of motion on the 17th of June.
So she can amend the relief that she seeks before this Court?
My Lord, may I suggest that I develop the argument and then deal with your questions? I am mindful of the time and also grateful for the 10 minutes reprieve given to me to deal with this issue, which sounds to me from comments today might be the most sticky from my point of view.
The Rule 7 issue.
Yes, my Lord.
Yes, all right.
So we make 6 points in support of this application. The first is that the present proceedings were instituted by Advocate Mkhwebane in her capacity as the Public Protector, not in her capacity, in her personal capacity. In that regard, the Court can contrast what she says in her founding affidavit. This is in the Part A record, Volume 1, page 10, paragraph 1, where she says, I am the Public Protector, and then says, I'm the applicant in this application in my aforementioned capacity as the Public Protector. So she's bringing it in her official capacity. Contrast that with her last affidavit filed yesterday in the 65E application, where she's listed now as the second applicant, and she says in paragraph 1, so the first applicant is the Public Protector of South Africa, the second is Busisiwe Mkhwebane, the second applicant. I am the Public Protector of South Africa and the applicant in this matter in both my official and personal capacities. So she's now seeking to litigate in 2 capacities. Just as a trustee does sometimes, they litigate in their personal capacity and in their capacity as the trustee of a trust. She started this case, and that is the point, in her official capacity. And incidentally, the letter which she has produced, which demonstrates her attorney's authority to continue acting for her, it's in the papers in Part B, in Volume 6, at page 601. It is PPRB1.
Page 601.
601. So this is the letter on which she relies for the continued authority of her attorney to represent her in this matter. PPRB1, it's her correspondence. It is a letter which is dated the 20th of December 2019, so more than 2.5 years ago. I said 2.5 years roughly before her suspension on the 9th of June 2022. And as the Court will see, it is written and signed by the Chief Executive Officer of the Public Protector, South Africa. It appointed Cianago Inc. to act, and I'm reading from the first paragraph, on behalf of the Public Protector in instituting an application against the Speaker of the National Assembly and others. As your Lordship presiding will know, the application in question was one which became case 2017 of 2020. It was launched on the 4th of February 2020, more than 2 years before the present case, 8500 of 2022, was instituted. We say that this letter provides no authority to Cianago Incorporated to institute the present proceedings, and certainly to continue with them after their authority to act for the Public Protector of South Africa had been challenged by my clients on the 23rd of June in these proceedings. But we say also, and in any event, that it's abundantly clear from this correspondence, and on their own version, that it was the Public Protector South Africa, and not Advocate Mkhwebane, which appointed Cianago attorneys.
It was that institution
It is indeed so.
that would fund the litigation and instructed Cianago attorney.
Correct. May I now draw the court's attention to section, the much talked about 1943 of the Constitution. It provides the President may suspend a person from office at any time after the start of proceedings of the Committee of the National Assembly for the removal of that person. So what the President does is suspend that person from office. In the case of the Public Protector, section 2A(7) of the Public Protector Act, which is in our bundle at page 320, provides, and I quote, "Whenever the Public Protector is for any reason unable to perform the functions of his or her office, while the appointment of a person to the office of Public Protector is pending, the Deputy Public Protector shall perform such functions." So what happened was the President suspended her from office. As a result, under 1943A, as a result, she was unable, for that reason, to perform the functions of her office.
From the date of suspension. Yes.
From the date of suspension. And those functions accordingly fall to be performed by the Deputy Public Protector. Now, in line with the President's letter suspending her from office, SAA1, and we give the references to the specific paragraphs, they're at page 300, paragraphs 614, 6.14 and 8, and the section of the Act to which I've just referred, we submit that with the effect of her suspension, the Deputy Public Protector, Advocate Galega, has been responsible for performing the functions of the Office of Public Protector. In other words, the functions of the office from which Advocate Mkhwebane has been suspended. And this is confirmed by Advocate Galega herself in a letter to the President dated the 14th of June, SAA2. The crucial submission which then follows is that one of the functions of the Office of the Public Protector in question is the continued prosecution of the present proceedings, which were instituted, as we've seen from paragraph 1 of the Notice of Motion, by the Public Protector in her official capacity. Another is the confirmation of the mandate of Cianago Incorporated as the attorneys of record of the Public Protector in the present proceedings. And as I shall demonstrate, in correspondence with Cianago Incorporated attorneys and in correspondence addressed to this court, both the Chief Executive Officer of the Public Protector as well as Advocate Galega have made it clear that she has not authorized the continued prosecution of the present proceedings by the Public Protector, and further that she has not mandated Cianago Incorporated to continue acting as the attorney of record in the present proceedings. And I'd like to take you to those letters because they are important. So the first letter is PPRB2. And I would emphasize that all of this correspondence is attached to her papers or to Mr. Cianago's papers. PPRB2, it's at page 603 in volume 6 of the present papers.
Volume 6.
603. And it is very revealing about what Mr. Cianago did once the Public Protector was suspended. That will become clear from this correspondence. This is a letter dated the 4th of July 2022. It's from the Chief Executive Officer of the Public Protector South Africa to Mr. Cianago Incorporated. And I refer the court particularly to paragraph 2 on page 603. As per our discussion, the Public Protector South Africa considered the request for the continuation of the provision of legal services at the expense of the Public Protector South Africa to the suspended Public Protector Advocate Busisiwe Mkhwebane. Then over the page 3.1 and subparagraph A. After consideration of external advice, the Public Protector South Africa resolved to propose the following terms for continued provision and procurement of legal and related services to Advocate Mkhwebane in relation to matters where she cited or litigating in an official capacity linked to the Office of the Public Protector. On Part B of the application in the Western Cape High Court, that's this matter, that the Registrar and all parties be notified that the filing of the amended Notice of Motion on the 17th of June 22 in the Part B application against the Speaker, the Chairperson of the Section 194 Committee, and the President is not authorised or mandated by the Public Protector South Africa. And a similar point is made in relation in 3.2b in relation to the application for leave to appeal. So that's the first letter, and that's what the Office of the Public Protector told Mr. Cianago on the 4th of July. The second letter is TS1. It's an annexure to Mr. Cianago's second last affidavit. It's in volume 8 at page 782. It is a letter from Advocate Galeka herself, dated the 6th of July.
So the page number?
782. TS1. A letter from Advocate Galeka, the Deputy Public Protector, to Cianago, Mr. Cianago of Cianago Attorneys, dated 6th July. And you'll see from the heading, it relates to the declaratory orders sought in case number 8500-2022, which are the orders that my learned friend referred you to today, as distinct from in the following letter, which is TS3, which is at page 788, that's his response. It's TS2, sorry. At 784, that case concerns the notice of application for leave to appeal in case 8500. So what did the Deputy Public Protector say to Mr. Cianago 2 days after the Chief Executive had written the letter to which I've referred? Well, we refer you to the whole of this letter, but specifically to paragraphs 2 to 6. We confirm that since the suspension of Advocate Mkhwebane as the Public Protector in terms of Section 1943 of the Constitution on 9 June, you required and in fact requested a new mandate and instructions for the continuation of the provision of legal services at the expense of the Public Protector South Africa to the suspended Public Protector in relation to matters you were reflected as attorneys of record on behalf of the PPSA. One of the matters affected by these developments is the matter of the Public Protector versus the Speaker, and then the case number is given 8500-22, where the acting Public Protector resolved that the PPSA would not proceed with this matter as the applicant and will not issue any new mandate and instructions after 9 June to you in pursuit of this matter in the name of the PPSA. You were advised that the Registrar and all parties will be notified that the filing of the amended Notice of Motion on 17 June 22 in the Part B application against the Speaker, the Chairperson of the Section 194 Committee and the President is not authorised or mandated by the PPSA. Please also terminate the brief of your counsels in this matter and take the necessary steps to withdraw as attorney of record on behalf of the Public Protector South Africa. Advocate Mkhwebane was advised that the PPSA would assume liability for the reasonable cost of proceeding of the matter in her personal capacity to challenge her suspension, as per revised estimates of cost to be provided by her attorneys of choice. So that was what the Deputy Public Protector told Mr. Cianago on the 6th of July. Similar things were said in the following letter, TS2 at 784, in relation to the application for leave to appeal, and you will see that in paragraphs 10 and 11 of that letter, page 786, Advocate Galeka, writing about the application for leave to appeal, notes with concern that Cienega Inc. didn't disclose to us that on the 4th of July you proceeded to file a notice of application for leave to appeal in the High Court in the name of the PPSA as the first applicant, and placed yourself as attorney of record for the PPSA despite having no mandate or instructions to do so. And the letter then goes on to say that the PPSA takes the reserves the right to take the necessary action to withdraw as the first applicant in that matter. And the last letter, one has to go back to the consolidated reply. It's PPRV4. It's at page 610, 611, in volume 6. And it's the letter which is sent to the registrar of the court on the same day, the 6th, advising of these developments and of the intended withdrawal. And we know that the withdrawal then followed. So, my Lord, the Lordship presiding mentioned that he hadn't seen the notice of withdrawal in this matter. It's in the notices bundle at pages 54 to 59. The operative portion is the withdrawal of, quote, the application under the above mentioned case number, that's 8500 of 22. It's signed by a new firm of attorneys, Salaji Govender van der Merwe Incorporated. We submit it is abundantly clear from the evidence which the Rule 7 application elicited from Advocate Mkhwebane herself and from her attorney, that Mr. Cienega's firm has no mandate on behalf of the Office of the Public Protector, in other words, the institution, to act on its behalf. And the only question, really, is whether a case which was instituted by the Public Protector in her official capacity, her words, is one of the functions of her office which have been transferred to Advocate Galeka by Section 2, capital A7. We submit that it obviously must be so, that all litigation instituted, official litigation, must be controlled by the person who's now in control of that office. Some remarks were made this morning about why are my clients, public officials, raising this point. Well,
it seems bizarre, because if I was in their shoes, I would want this matter dealt with on the merits so that whatever must happen, rather than having to focus on what is happening within the Office of the Public Protector, because now we must be detained with that. Whereas I think this is a matter that just requires attention so that it's dealt with and then everybody can get on with his or her business.
Yes, my Lord. With
I
respect,
said it in that context.
Yes, my Lord. And with respect, it is not bizarre for two reasons. The first is that it's clear, both from this correspondence and from certain correspondence which preceded the suspension of the Public Protector, but certainly from this correspondence, that the Public Protector wants to limit expenditure of public money on this matter.
That does make perfect sense.
Correct. And my clients are, in effect, Parliament, one of the three arms of government.
And it seems as if the acting Public Protector is busy pursuing that, is engaging with the attorneys for Advocate Mkhwebane to make it clear that it is her litigation which is being funded in her personal capacity.
What happened when this application was brought? It elicited a defence, which we submit is a bad defence, and it elicited what should actually have happened in the beginning from this matter from the outset. An application by Ms. Mkhwebane, or Advocate Mkhwebane, in her personal capacity to pursue relief which, if granted, is aimed at benefiting her personally. Why do I say that? It will terminate the impeachment inquiry underway before the Section 194 committee. It will reverse a suspension by the President. But prosecuting this case in the name of the Public Protector in an official capacity, on the other hand, will result in further costs being incurred by the Public Protector, the institution, public money.
But isn't that the point to be made in arguing for who should pay the cost, rather than for us to have to debate the issue of the mandate? Because as I see this Rule 7 issue, if we are with you all it means is that Advocate Mkhwebane is the applicant in her personal capacity.
Indeed, my lord, and that is not a trivial matter, because you then have the proper applicant before you, and the proper way to raise a concern of this kind about the mandate of an attorney to act for someone or to continue acting for someone is to utilise the provisions of Uniform Rule 7 sub 1. I submit this application was properly made. It is undoubtedly a good application, and we accordingly ask for relief in accordance with Uniform Rule 7 sub 1. We do not oppose her joining, as we say, in her personal capacity. If these two applications are granted, and if Cianaga Incorporated fails to prove his authority by providing a power of attorney signed by Advocate Galeka, which is what Paragraph 2 of the Notice of Application says, the practical effect will be as your Lordship presiding has indicated. The only applicant before this court, and rightly so, in respect of Part B, will be Advocate Mkhwebane in her personal capacity. And I'll return to the cost implication, the indication.
And now the fact that now the acting public protector is with what you said we shouldn't deal. You indicated that it would have an impact on the purported Rule 41 application. So what are the implications? If say we are with you.
There is no Rule 41 application, but if you're with me,
yes,
the effect will be that Mr. Cianaga will be disabled by the rule, Uniform Rule 7, from continuing to represent the public protector, the office of the public protector in this matter.
From a certain point in time.
And we know that the disability has existed from the 9th of June. So as far as the office of the public protector is concerned, it will be out of the case.
No, I'm talking in terms of the matter itself, because there's a Rule 28 which was filed, and I'm not sure now.
Okay, so we're not arguing on the technicality to say that there was no case to join if we're successful, if that's your concern. We are happy.
No, because it goes to them not being authorized to even file that Rule 28.
But now what has happened is that another application has been brought by Cianaga attorneys representing Advocate Mkhwebane personally, saying, in effect, I move for the relief being sought in the amended notice of motion based on the papers before you. And we have no difficulty with...
so the court will still be able to consider the matter on the basis of the amended notice of motion?
Undoubtedly, but with the correct applicant in front of you. And there will be no need for the Office of the Public Protector to take any steps under Uniform Rule 41, because the issue, the underlying issue, will have been resolved. Conversely, if the court's against us on this issue, then the Public Protector South Africa will be, it can only be because the court has come to the conclusion that notwithstanding the suspension of Advocate Mkhwebane, there was no effect on the mandate of Cianaga Incorporated to continue representing the Public Protector in the matter. And then both the institution and and Advocate Mkhwebane in her personal capacity will be before.
But then who withdrew the mandate of Cianaga?
Well, that's essentially that's the difficulty that this case presents, is that Mr. Cianaga maintains, based on a 2.5-year-old letter, that he is mandated to carry on, yes, but he has not produced a power of attorney. The Uniform Rule deals with this thing in a practical way. If my client is granted leave at this stage to challenge the authority, then it is incumbent on Cianaga Incorporated to produce a power of attorney duly signed by Advocate Galeka. If he doesn't do so, he can't act. And in fact, unless and until he does so, he can't act for the Public Protector South Africa. He can, of course, continue acting for Advocate Mkhwebane in her personal capacity.
But is this not a continuation of the proceedings in the start of Part A?
Sorry?
Is it not a continuation of those proceedings?
It is.
In terms of which he was so instructed?
Undoubtedly so. And what happened was, we've seen from the correspondence after the suspension, he went and asked the Public Protector, the acting Public Protector, do you continue with my mandate? And she said no. She terminated his mandate. It's something which happens every day. Why? Because she does not want this case to continue from an official perspective. She's got no difficulty with Advocate Mkhwebane challenging her suspension in her personal capacity. And in fact, is willing to pay for that limited aspect. It won't be lost on the court that what the office is not prepared to pay for is what I'm coming to now, is the continuation of proceedings against Parliament aimed at stopping the parliamentary inquiry. And the reason for that, the correspondence makes clear, is that what the office is prepared to pay for is a defence in the inquiry, not an attempt to stop it. That then brings me to the second point, and that is that these proceedings, as far as they concern the parliamentary respondents, my client, are an abuse of process in our submission. Now, the fundamental point is that insofar as Advocate Mkhwebane seeks relief in Part B against the parliamentary respondents on an urgent basis, it is an impermissible attempt to relitigate the relief that she sought and failed to get in her urgent application for interim relief pendente lite in Part A, which was heard on the 18th and 19th of May and dismissed by the full court, the per Erasmus de Lama and Villa full court on the 10th of June. And the court has seen from our heads we've analysed the relief which was sought in Part A, the relief sought in Part B, and the relief sought in Part B in the notice of motion as it stands to be amended. Incidentally, in the notice, the Rule 28 notice, the notice of motion as amended, which is at page 7 of the notices, contains as the second prayer, and prayer for an order granting the amendment to the notice of motion here in terms of Rule 28. And quite properly, because the Rule 28 notice itself...
Sorry, you said it's page?
It's notices page 7.
Notices page 7.
It is a prayer for an order granting the amendment to the notice of motion. And then the substantive relief that is sought is in paragraphs 3, 4, 5. Then there's a prayer for further and alternative relief in 6 and a prayer for costs in paragraph 7. But the point that we wish to make, and we'd ask the court to contrast or compare this notice of motion, the amended notice of motion, with the notice of motion as it read at the time that the Part A court took its decision. That is SPP 1 in volume 1 of the Part B papers at pages 47 to 49. And what is clear is that although the relief then and the relief now is somewhat convoluted, in essence, what Advocate Mkhwebane sought from the Part A court were orders prohibiting the National Assembly. I'm talking simply now about the parliamentary respondents, and specifically the 194 committee from continuing the process under Section 194 of the Constitution for her removal from office, pending the outcome of the second CC rescission application. And perhaps I should just explain that aspect. So if you go and look at the relief which was then sought, this is SPP 1 at page 47. Two parts to Part A.
Page
47 of the papers, volume 1. Part A was for an order pending the finalisation of B, granting interim prohibitory interdict and mandamus in the following terms, and one sees prayers stopping the proceedings from carrying on. Paragraphs 1.2 and 1.6. That's pending the finalisation of Part B. And if one then goes and looks in Part B, well, what aspect of Part B has to do with the continuation of the proceedings? You will see there's only one aspect there, which is, aside from the development of the common law part, to which I shall come, and that is in paragraph 1.3 on page 49, the conduct or decision of the committee to commence or proceed with Section 194 removal proceedings while the matter is sub judice. It was based on the sub judice rule, and what matter was it that was sub judice? As my learned friend said in argument, and as the Part A court recorded in its judgment, and as my learned friends for the 10th and 11th respondents have again confirmed today, the matter, which is sub judice, at the time that the Part A case was decided, as at today, is the second CC rescission application. So what would, in effect was sought in that case was an order stopping Parliament from carrying on while the second CC rescission application was pending.
Sorry, I may just have missed that, because I was just about to ask you, as I understand it, Part A was seeking an interim interdict pending these proceedings.
Correct. Not these, no, pending Part B. But if you
just take me to that part that makes that distinction, because it's a very fine distinction.
I understand.
It might have escaped me.
So it takes you into Part B, and then you ask yourself, well, what part of Part B are we talking about? And if you look at Part B...
No, take me first to the notice of motion in Part A.
Yes.
So that I can then be able to follow.
I understand. 47, bottom of the page, paragraph 1.
47 of volume 1.
Yes. Paragraph 1, the introductory portion.
So I must not look at the notice of motion. I must just look at the...
You've asked me the Part A, as Part A as it was before the court which decided it. It's SPP 1 at pages 47. It's an answer to Advocate Mkhwebane's founding affidavit. It's not in the notices bundle, it's in the main bundle 1. Volume 1.
Volume 1 of Part A.
No, volume 1 of Part B.
Oh, I'm looking at the wrong volume.
Sorry, she's attached it as the first annexure to her founding affidavit.
Because I have in front of me the notice of motion in volume 1 of Part 1, or Part A, sorry.
Yes, that was amended twice.
Oh, that was amended during the course of litigation.
Yes, twice. The last amendment actually came after judgment was reserved. That's why if you look at the date of that notice of motion at page 51, it is the 20th of May 2020. I mentioned to you that the case was argued a couple of days before that.
I see.
If you look at the bottom of that first page of the notice of motion, page 47, para 1, you will see pending the finalization of Part B, and then there are two relevant paragraphs, presently relevant paragraphs, 1.2 and 1.6, and together those things say essentially the same thing. Don't carry on with the Section 194 proceedings in Parliament. And it's pending Part B. So then one goes to look at Part B, and what part of Part B is relevant to that? It's at page 49. It is a declarative in terms of 172(1)(a) of the Constitution that the conduct of the decision of the committee to commence or proceed with the 194 removal proceedings while the matter is sub judice is unconstitutional. So the practical effect of these two parts read together was, because that matter, which is sub judice, is the second CC rescission application, is that they wanted an interdict stopping Parliament from carrying on with the 194 committee until the second CC rescission application had been determined.
I think you are skipping a step there. As I understand it, they came to court to say to the court, give us an interdict, because we are now going to seek a final relief which has the effect of suspending the proceedings pending the decision of pending the decision.
So the question, and the court inquired into this, was what pendente what? It can't be just Part B in and of itself. It is, because it's based on the sub judice rule, it's the second CC rescission application. And they made it abundantly clear that that was their intention with the last amendment to this notice of motion, because if you look at the second paragraph of Part A, you will see...
Sorry, let me just interrupt you so that I can clarify this in my mind. In Part A, the issue is never determined finally. So if they had succeeded, they would still have had to come to court so that the court can determine that issue finally. And what issue was that? This was the issue of saying the proceedings in Parliament cannot proceed because there is pending decision. So this is what we must decide, finally. So in the first instance, they did not obtain the interdict. Now they are not seeking an interdict before us, they are seeking an order which would then mean that if we are with them, if we're with the applicant, which would then say, stop the proceedings until the Constitutional Court determines the...
It will have exactly the same effect. It will be an order stopping Parliament from carrying on until the second rescission application in the CC is determined, and that was what they were trying to achieve.
But at that, no, they were not achieving. They were saying, we are going to come to court. We come to court on an urgent basis. There may be issues that we may need. I mean, this issue of coming to court in two parts is kind of a normal, it's become a new normal. Because, of course, in the first...
Now, let me develop the argument, and then you'll understand where I'm coming from. I wanted to refer you to paragraph 2, if you don't mind.
Okay.
Because in paragraph 2, as they amended it, they wanted an order in terms of Uniform Rule 45A, alternatively 172(1)B of the Constitution, this is part of Part A, suspending the operation and execution of paragraph 118A1 of the order of this court, as amended by the Con Court. In other words, they wanted to undo what the Constitutional Court had done when it upheld the appeal in relation to the 129V participation of a judge on the independent panel, pending what? The finalisation of B and all the applications filed on 11 March and 11 May respectively in the Constitutional Court. They wanted, in other words, amongst other things, a final interdict pending the outcome of CC rescission 2. That's the 11 May 22 application.
Now, as I read it, Mr. President, is that Rule 45A has got an effect which is similar to that of an interdict. Isn't that so? Where it can stop the execution of a judgment.
Pending at this, as far as what I'm emphasizing, the only pending application at that stage was the CC rescission application, Part 2, as well as Part B. But Part B is directed, because I've indicated in 1.3, at CC rescission 2. My learned friend said as much, and that's why the court deals with CC rescission Part 2. Where am I headed with all of this? It's very simple. They wanted practically what they wanted, and they came to court urgently to get an order from this court stopping the parliamentary proceedings until the CC rescission application Part 2 was decided. That's what they wanted. They didn't get it. What did they then do? Barely a week later, they applied to amend their notice of motion to seek, in practical terms, exactly the same relief again, on an urgent basis.
But had the circumstances not changed then, because question thereafter the public protector was suspended?
It's got absolutely nothing to do with the parliamentary proceedings. There's a fundamental error that my learned friend made today. His dominoes will fall. If the court were to set aside the suspension of the public protector, that will not affect the Section 194 proceedings in Parliament one bit. Because
now I think you said that in the context of the interpretation of this.
But the two are entirely separate, in other words. The first set of proceedings is a parliamentary process.
Yes.
It happens under Section 194 and the rules. The suspension is a function or a job of the President as the head of the National Executive, or the head of the state. I'm not sure which of the two.
So what you are saying is that in as far as the parliamentary processes are concerned, the only possible impediment that is being raised by the applicant is the rescission, not anything to do with the interpretation of Section 199.
Absolutely nothing had changed.
Yeah.
I was astounded when a week later, with nothing changed, they come to court under a new notice of motion when they seek in effect the same relief as they sought before. Having failed to get it, they want essentially the same relief again. It's about the substance of it. And we say there has to be a stop to litigation. One cannot, through this contrivance of Part A and Part B, where with convoluted formulations of relief, you ultimately seek the same thing. You fail to get it from 3 judges of this court, who heard argument over several days, anxiously considered the matter and delivered a full reasoned judgment. You come straight back to court and effectively ask for the same thing, and to add insult to injury, you seek leave to appeal against what they have ordered. And then there's a further difficulty, and that is this. If I could ask you to compare 2 other aspects of the current matter. In Part in Part A of the previous case, at page 48, they wanted an order pending Part B, and I quote, that the Speaker be mandated to withdraw her letter to the President dated the 10th of March 22. That correlated in Part B to an order declaring the conduct of the Speaker to issue the letter to be unconstitutional and invalid. But if you direct someone to withdraw a letter, which they've written, which is the relief that they were seeking, that is not interim relief as we argued. It's in effect final relief. You're saying she must withdraw this letter. They seek essentially the same relief through the declarator in these proceedings. The Part A court dealt with the matter of this letter and ruled on it. And they've come back again on an urgent basis. And the last point is, and perhaps this is the most telling of all, do you think she genuinely wants this relief against Parliament? Or is this case really about the suspension? You've heard argument uphill and down Dale today, mainly about the suspension. But what did Mr. Sianago say in his correspondence to the Public Protector when they were debating the issue, including especially of fees? You'll remember the Public Protector had indicated that she was willing to fund personal litigation by Ms. Mkhwebane to challenge her suspension and nothing else, not to challenge the proceedings in Parliament. I ask you to turn to volume 6 of these papers, at page 606, at paragraph 8. That is PPRB 3. This is a letter from Mr. Sianago to the Office of the Public Protector, the CEO. It's in response to that letter of the 4th of July to which I referred. Paragraph 6 at the top of page 608. Incidentally, I quote, the main issue which necessitated the amendment and lodgement of the urgent Part B application proper case on about the suspension. Then we ask for punitive costs because the Constitutional Court has been made it clear that one of the circumstances in which a personal punitive cost order is indicated is where there has been an abuse of the process of court, and rightly so. My Lords, I'm indebted to you for sitting late. My client's prayer in this matter then is for the following relief. Firstly, orders in terms of paragraphs 1 to 3 of their Uniform Rule 7.1 application. And secondly, an order dismissing the relief sought against...
So just repeat that order in terms of?
Prayers 1 to 3, paragraphs 1 to 3 of the Notice in Uniform Rule 7.1 application, and an order dismissing the relief sought against my clients in Part B of the applicant's notice of motion with costs. We ask for punitive costs on the attorney and client scale, including the costs of 2 counsel, and they must be paid by Advocate Mkhwebane personally. I omitted this morning during the housekeeping session, to raise with you the position of myself and my learned junior, Mr. Nadi. Your Lordship may have seen from the correspondence.
I think you have requested to be excused tomorrow.
That's right.
So that only one of your juniors will be present in court tomorrow.
Yes, my Lord. We're in Justice Delama's court tomorrow against one another. We ask your leave to be excused in those circumstances. Mr. Tofi has assured me that he will watch the rest of the proceedings, which will consist obviously of listening to the case presented for the other respondents opposing and the reply.
You are then excused for tomorrow, and thank you.
I'm grateful. Those are submissions.
Yes, Mr. Mpofu?
My Lord,
is it something that can wait until tomorrow?
Yes, unfortunately, my Lord, but it's small. Just in fairness to Mr. Breitenbach, because I know he's not going to be here tomorrow, but maybe Mr. Tofi will deal with this point so that they can advise each other. There's one point that I omitted to mention apropos this issue about representation, and I'll just mention it so that they can then deal with it if they want tomorrow. It's page 196. Volume 2, my Lord.
Volume 2 of Bundle B.
Yes. There's a letter, the letter that my learned friend just read from Mr. Janchi, one of his clients. And 196, that's 19 starts at 195. I think that's the wrong. Sorry, my Lord.
19.
It started at 195, my Lord.
196, yes.
Yes. And I just wanted, because remember the whole thing is that something called the Office of the Public Protector is the applicant, which is not, there's no such thing on the papers. But they say that I believe a 2-week period will be sufficient given that you, meaning Mr. Siane and Advocate Mpofu, have represented Advocate Mkhwebane since early 2020 and so on. And then they refer at the last sentence, I bear no personal knowledge, and her urgent application in the High Court for the interim relief has now been heard, meaning Part A. And I just wanted to maybe to raise that in fairness while he's still here, because what that does to his Rule 7 application.
All right, thank you, Mr. You want to?
I have no submissions on that letter.
Thank you, Mr. President.
Thank you, Madam.
The court is adjourned.
No, it's fine.
This is something I actually picked up this morning, and I thought I was going to listen to it. Now, so I didn't know if the trophy to be to say.
No, it's fine. I've really made my submissions.
No, it's fine.
Thanks very much, Dahlia.
No, thanks. Good luck tomorrow.
Yes,
or
I need
to
it.
one of you, whoever.
I need it.
You have a formidable opponent.
I do.
Good luck tomorrow.
Thank you very much.
Oh, you can sit there. Okay.
evening.
And maybe that time and yes. Like me and Tambeka. You know, one day with this.
I think we got our points across. I don't know, we are got the wrong
I'd like to know which ones you take. This rule, these ones. Eh? No, put it in the bag, no, we need that. And, no, I want the rest of... No, I don't think I need this stuff. This is part A. Hang with? Oh no. Okay. No, this
Are we leaving this?
No, I think I'm leaving this one here. Yeah, let me carry this. So, here, in your bag. They mustn't get lost. Yeah, it's the people's bag. Yeah. Okay, can I have mine? No, mine I still put some of my phone.
5 to 8.